Be cool, be kind, be classy. The cupcake's so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and the Shakeouts. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good afternoon. Good afternoon, cupcakes. Wow. Thank you to all the teachers who sent me this new trial to cover. We're jumping in. We're going to jump right in. This is a last minute add-on to our trial calendar. This trial should be over by Friday. And so when a couple of you sent me emails about it, I started watching it this morning and I had FOMO. I said, oh my God, we need to cover this trial. It's short. It's going to be over by Friday, allegedly, apparently. The defense moved for an adjournment, a continuance yesterday and today. They picked the entire jury yesterday, which I find crazy. And I think what I want to do is something that has never been done on this channel before. Well, two things. Number one, I don't know how I feel about this case yet. You know how I say I hate sitting on a fence? I hate sitting on a fence because the only thing that happens for me sitting on a fence is I'm going to get injured. I don't know enough about it to know even how I feel about this yet. It's very conflicting. I feel very conflicted in my head. And so I think what we should do is watch this trial as if we are jurors. I think that we should not watch any of the arguments outside the presence of the jury that the attorneys make. I want to watch only what the jurors are seeing, openings, witness testimony, etc. I didn't watch the civil trial, so I don't know. I didn't watch it, so I don't know. Many people might have opinions about it already. I don't. Scott, I know already has opinions in here because he's 25 years retired from NYPD, and he says he used to deal with the schools in Brooklyn, and he had a lot of opinions before the show started. And so I'd prefer not to have spoilers and stuff, but I will tell you this as far as background goes. Here's the scoop. Here's what this trial is about. Okay. This trial is about, on January 6th of 2023, a 6-year-old first grader went into Richneck Elementary School in Newport News, Virginia, with a firearm that he had taken from his mother's purse. Apparently, he climbed up on a tall bureau and retrieved this firearm from his mother's purse. It was a hand pew-pew, as we have to say in the very beginning of the stream, because please don't put even the word, only that, even that 3-letter word in the chat. YouTube hates it. A lot of YouTubers were stricken for an attorney recently waving around a firearm in court because apparently they think we're, promoting it if we talk about it. 6-year-old goes into school with this weapon and shoots his first grade teacher in front of the whole entire class. Maybe they were leaving. I don't know. We got to find out more. We got to listen to the witnesses. The teacher's name is Abby Zwerner. She was in the hospital for almost 2 weeks. She had 6 surgeries and she survived. The bullet was very close to her heart. She's very, very lucky that she survived. She did sue civilly. She sued this assistant principal, Dr. Ebony Parker, who is now on trial criminally. Abby Zwerner sued Dr. Parker in civil court and won a $10 million judgment against her, or verdict. I believe that verdict has been stayed pending some post-trial motions. I don't think any money has been collected yet. The allegations in the civil case were that the she's now former assistant principal ignored any warnings or concerns that people had that this child may have had a weapon with him that day in his backpack. So now the former assistant principal is on trial, Dr. Ebony Parker, for 8 felony counts of child endangerment, 1 for each bullet that was in the gun. 1 was shot. There were 7 left. 8 felony counts of child endangerment, which carry up to 5 years per count. So she's facing up to 40 years in prison. And this is a failure to act case. This is not saying she did something improperly. This is a failure to act criminal case. And I think, you can correct me if I'm wrong, this is the first time that a school administrator is ever facing a criminal trial because of failing to act in a school shooting. We have seen other cases regarding school shootings where parents have been charged because their teenager, in the Crumbly case, brought a weapon to school. We have seen criminal trials in which safety officers have been criminally charged. But I believe this is the first time we are seeing a school administrator being criminally charged, and this is in the Commonwealth of Virginia. And the mother did get charged. The mother was charged. I don't know if she pled guilty or she went to trial, but she's serving something like 4 years, I believe. I forgot to put that in the show notes, but the mother was charged. And I think she's serving up to 4 years or 4 years, right? So the mother's already in jail. I don't know if she's serving her time. They've already charged the mom. Now they're going after the former assistant principal. Thank you, Jeff, for asking the question, because I forgot to put it in the show notes that are below this video. And so first day of trial ended today, 4 p.m. Eastern. Tomorrow we can jump into it. Maybe we'll start a little bit late in case, there's any attorney arguments, because that way we can skip through that stuff and just watch the testimony. And so I don't know. I don't know how I'm going to feel about it. But what we got to do before we even start is check out our motivational quote of the day. This judge also, does anybody know this judge's name? In all the articles that I could find, I could not find the judge's name, and I really like her. I think you're going to like her too. She's really, she seems so far, she seems really fair, and I like her. And in fact, at the beginning of the day, she addresses the media and lets the media ask questions, which is interesting. I've never seen that before in any of the cases that we've covered, which is why yesterday, when we tried to cover the Alvin Campbell Jr. trial in Boston, the feed was cut. The feed was cut because there was a very strict media order. That was a grape case for 9 victims of this alleged rapist who posed as an Uber driver. And we go around downtown Boston and pick up very intoxicated women. He would target them and then grape them and then film the grapes. And then when prosecutors or law enforcement got a warrant for this guy's iCloud data, they found all of these videos and they contacted some of the women. But yesterday, when we tried to start watching the trial, the media, against the media order, and it really wasn't anybody's fault, they were not supposed to broadcast any of the victims' names. And because the victims' names were used not only in openings, but in the reading of the charges, they had to pull the cameras from that courtroom. So I don't think they're definitely not live streaming anymore. I don't know if they're going to broadcast any parts of the trial on Alvin Campbell Jr. in Suffolk Superior Court, Massachusetts, but we're going to just jump right down to the Commonwealth of Virginia to check this case out, because I just don't know how I feel about this criminally yet. Miles Monroe, this is your motivational quote of the day, said, "Leadership is the capacity to influence others through inspiration, motivated by passion, generated by vision, produced by conviction, ignited by purpose." It's kind of an interesting motivational quote for Tuesday, May 19th, 2026, considering we're talking about the defendant here who's in a leadership position, right? One more time. Leadership is the capacity to influence others through inspiration, motivated by passion, generated by vision, produced by conviction, ignited by purpose. Miles Monroe is your quote of the day. And there it is. I know we have a lot of teachers in the chat, so I'm anxious to hear your thoughts when we get to talking about our thoughts on this, because it's hard for me to run the stream and follow the chat, so I won't be able to do that as we go. Here is your empowerment card of the day, because who doesn't need a little empowerment every single day? Many of you may have watched this already today, and if you did, please no spoilers, but welcome, because we're doing it. Oh, here it is. Here's your empowerment card of the day. Ready? Bad vibes don't go with my outfit. How do you like that? Bad vibes don't go with my outfit. That's your motivation. That's your empowerment card of the day. What trial was it? We were watching something recently where somebody said something about the vibes. What was it? Remind me. And I was like, oh, gathering of the vibes. Just here for the vibes, remember? Bad vibes don't go with my outfit. The best one yet. I think that's good. I think that might be the best one yet. All right. I know for some of you that it is very late in the evening. And it's late in the evening. And I'm sorry, but this is when I was available today. And then I wanted to jump on in the middle of the day. But then I was like, oh, maybe you guys are already watching it. We can watch it again. All right. So Mila, that's what it was. It was Mila, Stephon Diggs's accuser. Mila was there for the vibes of the Pats game, right? She doesn't know anything about football. She was just there for the vibes. I knew you'd remember that, Emily. I knew it. Crazy, isn't it? How the Commonwealth of Massachusetts charges someone like Stephon Diggs without doing any investigation whatsoever. And then they let a guy like Alvin Campbell Jr. go on and grape several more women after his 2016 DNA hit. It's wild to me. It's crazy. And CB10 is like, that's perfect because I'm wearing the no crying on the yacht sweater today. Okay. I've only watched a very little bit of the judge this morning, and so I'm just watching her talk to the media. So Bachwood says, sorry, but I was not impressed with the judge. Okay. All right. Thank you very much. Let's get into court and check it out. They're on a half an hour delay, which is what someone just told me, and which is what the media told the judge in the beginning of the day. We're on a half an hour delay. So is there anything you want us to do or you don't want us to do? And so some of you said you watched it today and it wasn't the same without me. And I appreciate you so much. Let's listen to her address the media a little bit this morning. And then I may put it on 1 1/4 speed or 1 1/2 speed to get through the testimony so we can catch up today and then start fresh again tomorrow. Okay. All right, here we go. Does anybody know the judge's name?
And is counsel first to respond?
No.
The ruling, I believe, made by Judge Appeal on that stands. So the ruling will remain in the court rules. Okay, anything further from the defense?
No.
Okay, and I believe the media press asked to do something. I wasn't quite clear on what I was being asked. So somebody could first announce who you are and then make your request.
Okay, so that's me and that's the court. I may have to, as they get into it, may have to get a little more modulated, but also we're lucky enough to get captions on this one. Shout out to Long Crime.
Hi, yes, Brendan Ponton from WTKR Channel 3. We were asking if we could put a second microphone on the witness stand, just so we could be able to clearly hear what people were saying.
Praise be. Can you imagine a reporter asking if they could put another microphone on the witness stand so they could hear it and make the sound better for all of us? Wow, amazing.
Okay, this will be a wireless or wired mic?
Wireless.
Wireless, okay. And we'll turn it off when we're not in session?
Yes.
Okay, not a problem. Yes, you may approach to do so now and then let me know when you're ready. And then while they're doing that, Chair, did all the jurors report? We have 14?
We have 14. I believe 13 news also had a question.
Oh, we have another. Oh.
All right, somebody said court is way loud. Is that better?
Okay, while he's doing that. Okay, yes, ma'am. And state your name.
Yeah, Madison Schlegel with 13 News Now, Your Honor. Obviously, we're on a 30-minute delay with for information that needs to be redacted.
It goes up and down. It goes up and down. Let's just get to the
How you would
openings.
like us to.
But she addresses the media in the beginning. And then we're just going to skip right to the prosecution's opening. And here it is.
I'm assisted by my paralegal at counsel table,
Okay, that's the court. That's me, and this is him.
Megan May. And I thank all of you, as the judge has said, for your service. I know it is
It's just gritty. The sound is gritty. All right, then I'm going to try not boosting it at all and see if it's clearer for you.
inconvenient.
This is it, not boosted at all.
But this case is important to all involved. And I thank you for doing your duty. And I know
That's without the boost. So you get what you get and you don't get upset, or you can keep complaining and then the mods will just, get rid of you. It's up to you. Tell me if you can hear it without a boost. Here it is. Hold on. It's okay. All right, here we go.
Guilty, and we are now ready for opening statements. Would the council like to give an opening statement?
Yes, Your Honor. Thank you.
Please approach.
On January 6th of 2023, at Richneck Elementary here in Newport News, there was one and only one person who had both the authority to take action in a crisis and the knowledge that a crisis was underway. My name is Josh Jenkins. I am the Commonwealth's attorney assigned to prosecute this case. I'm assisted by my paralegal at counsel table, Megan May. And I thank all of you, as the judge has said, for your service. I know it is inconvenient to be a juror, but this case is important to all involved. And I thank you for doing your duty, and I know that you will. On January 6th of 2023, parents of children who went to Richneck Elementary and the children themselves woke up to a normal day. They packed lunches, got on the school bus, got in their cars. One walked to school that you'll hear from. And to them, nothing was different that day. And as the parents watched their children, backpacks in tow, walk into that building, those parents entrusted the care of those children to that school. They had a promise that when I bring my child into school, the school will keep them safe. But the evidence will show you that that's not exactly what happened. I understand, and perhaps you understand, that in this incident, a teacher was shot. That is a horrific tragedy, and I do feel for Ms. Werner. But this case is not about Ms. Werner. This case is about the children who lived through this event in Ms. Werner's classroom, 20 of them. That's what this case is about. You will hear from that teacher because she witnessed the events, but she is a witness. The victim of this crime are the children. The defendant, Dr. Ebony Parker, was the assistant principal at Richneck Elementary at the time. She was the person who was paid to take care of those children. And around 11:40 a.m., Ms. Werner had seen a particular child who you will learn has a long history. A long history of discipline issues of which Dr. Parker was already aware well before January 6th of 2023.
Okay. You want it sped up or you don't want it sped up? This is not on 1 1/4. I was going to let the attorney speak at regular speed because the openings are very short. I'll put it on 1 1/4 for now.
But Ms. Werner observed something about this student that worried her. You're going to hear from her, and you're going to hear what that concern was. And then she's going to tell you that she went to Dr. Parker and warned her that this child, who we refer to as JT, was in a violent mood. You'll hear that she said, "I don't know what I'm going to do if he hits me." That is the knowledge that Dr. Parker had of the history of JT, that and more. But at 11:45 a.m., Mrs. Werner walks in, tells Dr. Parker that JT is in a violent mood, and Dr. Parker does not respond to her, stares at her blankly for just a moment, and then returns to her work in her office. The warning ignored. You're going to hear that this child's past means that no warning should be ignored, because you're going to hear from a teacher that taught JT the year before. You're going to hear about the violence that that teacher experienced at the hands of a kindergarten. And you're going to hear about the report that that teacher made to Dr. Parker in that year. And that Dr. Parker's response was blank stare, look back down, do nothing. The same response she had at 11:45 a.m. on January 6, 2023. But that warning was not the only warning. At 12:20, a reading specialist tells Dr. Parker that she thinks maybe JT has a firearm. She says maybe it's a toy, maybe it's real, I don't know. She thinks JT has a firearm. She says, I'm going to search his backpack. Dr. Parker really doesn't reply to her, but she goes and searches the backpack. Doesn't find anything in the backpack. Meanwhile, there are some concerning observations that are happening on the playground with JT. And you'll learn why teachers and counselors then come to expect that JT has taken that firearm out of his bag and put it into his coat and is carrying it around on a playground full of elementary age students at Richneck Elementary School. You're going to hear that he showed it to another brave student, who then reported, young RR reported exactly what he had seen to a teacher. He was terrified, understandably shaken, crying when he reported what he'd seen. At 12:30, that reading specialist goes back to Dr. Parker and says, I think he has the gun in his jacket. Do nothing. His mom will be here soon, she says. I can only imagine how that made RR feel. But around 1 p.m., a counselor goes to Dr. Parker and says, I want to search the child. Can I search this person? She says, no. Mom will be here soon. For over an hour, multiple people went to Dr. Parker and told her there was an armed child at an elementary school running around with, interacting with children in the classroom, children on the playground, children in the hallways. Multiple warnings brought directly to her. She says, do nothing. Does she say, search the child? No. Does she say, call the police, or does she call the police? No. Does she remove the child from the classroom and separate it? No. She didn't even get up from her desk. She didn't even leave her office. Warning after warning after warning, she did nothing. The crisis in this case did not begin with the firing of a gun. The crisis in this case began at 11:45 a.m. when Ms. Werner initially warned Dr. Parker that there was a crime. That was the moment Dr. Parker should have left the office and investigated this. There is a moment that will be described to you by a witness on the stand this morning, where after all that she now knows, all the suspicions that she's now heard, and repeatedly she's heard people that Ms. KOVAC and others are going and telling Dr. Parker, she sees JT in the classroom wearing a big coat. She's nervous, and if in an instant she sees him pull out that gun and aim it directly at her face, and before she has a chance to do anything but raise her hand up, JT fires that weapon. It hits Ms. Werner At the moment that he fires that weapon, there are 19 children. Right there. And that's why I tell you that this case is not about Ms. Zwerner. This case is about the 19 children whose lives were endangered in that moment, but in the moments before as well. Those children were, some of them, between the gun and Ms. Zwerner. Some of them, a slight movement of the gun could have hit a child instead of Ms. Zwerner. They're right there. Some standing shoulder to shoulder with the shooter. All of them, you'll learn, watched as their teacher clutched her chest and bled before these children, screaming in horror, ran across the hallway to another teacher's classroom, and Ms. Zwerner ran to the office and collapsed on the floor. Where, at that point, was Dr. Parker? She had locked herself down in her office. Was the school on lockdown? Not yet. Still no. But a few minutes after Ms. Zwerner enters the room, a receptionist, Ms. Olvera, does finally put the school on lockdown.
So this criminal trial has nothing to do with the shooting of the teacher. This is only child endangerment charges against the other students. I mean, on behalf of the other students in the room. It's very interesting. Has nothing to do with the shooting of the teacher.
I commend her for doing it. She should have had it. And it was too little, too late. Back in Ms. Werner's classroom, Ms. KOVAC has shown up, the reading specialist I told you about earlier. She knows JT. She knows his history. And when she heard that gunshot, she knew exactly what happened. And she went straight into that classroom. She found in that classroom the gun lying on the floor. You'll learn that that gun contains 7 rounds, one of which, 7 rounds plus one that was jammed in the action of the firearm. So 8. That was unspent. Amy KOVAC enters that room and she just puts JT in a bear hug as she calls 911. She holds that child there until police arrive. She will tell you that that whole time she was saying he was cursing. He was saying, explaining that he shot his teacher. And she was saying, like the consummate faculty teacher she is, don't use that bad language, you know better. She's just doing the best she can to control the situation alone in a classroom where a teacher has just been shot. Ms. KOVAC, the reading specialist, also the one who searched the book bag after telling Dr. Parker that's what she said. A task that I don't think reading specialists are supposed to do in an emergency. And the reason that I don't think that is because school policy at the time said exactly. Richneck had adopted a crisis management plan. And that plan required teachers and faculty members to report crisis situations to administrators, and it required administrators to take actions. One such policy from the Newport News handbook, you'll learn, was that in terms of searching a student, that could only be done by an administrator or a school security officer. And at the time of this shooting, there was no school security officer at this building. They shared their security officer with another building.
Okay, that's another big problem for me. There was no school security officer at the building. They shared it with another building. That's another big problem for me right now. Understand also, I see a lot of you talking about the civil trial. The burden of proof in a civil trial is much, much lower than in a criminal trial. In a civil trial, it's just, a little bit of a tipping of the scales, but this is beyond a reasonable doubt standard. There are also different issues in the civil trial. The civil trial was for the injuries sustained by the teacher in the shooting. These criminal charges are for child endangerment for the other children in the classroom, not the teacher. So just because you felt one way on the civil case may not mean that you're going to feel the same way on the criminal case. It may mean that you are. But again, very different burdens of proof. And they did not have a school security officer. I got to hear that again. So she's the only one in the building who's allowed to search the backpack? Okay, let me take this back a little tiny bit.
Was that one such policy from the Newport News handbook you'll learn was that in terms of searching a student, that could only be done by an administrator or a school security officer. And at the time of the shooting, there was no school security officer at this building. They shared their security officer with another building, and so the security officer was at the other school. So at the moment of this crisis, there were exactly two people in the building who had the authority under policy to take action. And those two people were the principal, Ms. Newton, and the assistant principal, Dr. Parker. But let me remind you of how I started today. There was only one person that had both the knowledge of the ongoing crisis and the authority to act. While Ms. Newton, the principal, certainly had the authority to act, she had no idea about any of this. Because Dr. Parker, nor anyone else, bothered to tell her. Ms. Newton, you'll learn, didn't get any of these suspicions that day. She didn't know any of this was happening until there was a gunshot. So she had authority, but no knowledge that there was a problem. It's only Dr. Parker that had both of those things. When you hear from these faculty members, they will tell you that they wish they had violated the policy. In hindsight, there'll be no question. They regret it. They regret following Newport News policy. They will tell you to a person that they wish they had just searched the kid and gotten the gun, or they wish they had just called the police. That's what they say in hindsight. And you know what? I would bet that Dr. Parker also wishes she had done differently. I do. But here's the difference. The policies that were in place enabled, in fact, required Dr. Parker to act. The teachers, on the other hand, and faculty, if they were to act, they'd be acting against the policies that were in place that day. And that is a significant difference. There was only one person in the school that day that had both the authority to act and the knowledge of the ongoing crisis. And that person, you'll see, was Dr. Parker. Many people knew the crisis had begun. Two people had the authority to do something about it, but only one person had both. During the course of this trial, we are going to mention a lot of initials. We're not saying that.
Here's my other question. If this child who is 6 years old already had a long history of violence and really dangerous behavior in the school, why would they forego having a school security officer in this particular school? I don't know. And if you are a teacher and you knew something like this was going on, would you have taken action and begged for forgiveness later, even though it might have been against school policy? If the assistant principal, who he's saying is the only one who had knowledge and authority to act, was doing nothing, would you do something? I'm not saying that the other teachers are at fault. I'm just wondering, I know there's a lot of teachers in the chat. What would you do? Remember that TV show, What Would You Do?
The names of the children, we are going to mention a lot of initials. We're not saying the names of the children because we don't want to put their names out to let this be their story forever. We're asking everyone that testifies, and all of the personnel will definitely be using initials. I say that because that's going to be a lot of initials. The judge talked to you about taking notes earlier, and it is your choice. These will be distributed to those who wish to take notes here in a few moments. Let me encourage you that almost all of the important evidence in this case is going to come out piece by piece by piece, puzzle, little detail by little detail, from several witnesses who will take the stand and testify. And when you go back to deliberate at the end of all of this, all you'll have is your memory and your notes to help refresh you. You won't be able to have testimony read back to you, as the board pointed out. And often I've had the experience of jurors deciding to ask a question, which is, what did so-and-so say in your testimony? And they're always told by the judge, we can't answer that question. You have to rely on your own memory. And so I'm just giving you.
I don't like that. No readbacks in Virginia either. In New York, we always have readbacks. If the jury wants to hear from what a witness said, the court reporter will come back in and read their testimony to them. No readbacks in Massachusetts, no readbacks in Virginia. I don't like it. What we did learn here at the end of the day is that the jury is allowed to ask questions. So maybe, hopefully, they will ask questions, because one juror at the end of the day today did have a question that the juror is going to bring in tomorrow. So they have to rely on their notes. There we go.
You can't answer that question. You have to rely on your own memory. And so I'm just giving you
Or memory.
We're going to be throwing a lot of initials at you, a lot of details at you. And when the judge instructs you on the law at the end of this process, you'll have to remember all those details in order to decide this case. So I do ask you to really pay attention to the witnesses, and I suggest that you take notes to help refresh your own memory, because at the end you will have heard a lot from a lot of people. January 6, 2023. 20 students went into Ms. Zwerner's classroom, and their lives were forever changed. The trauma that they experienced is unspeakable, and you will hear from some of the parents about that trauma. That shouldn't happen. And the one person who had both the authority and the knowledge that a crisis was ongoing is the reason that it happened. And we think at the end, the evidence will show you exactly.
The defense like to give an opening statement.
Yes, Your Honor.
Okay, here comes the defense
May it please
opening.
the court. Mr. Jenkins, ladies and gentlemen, you found out yesterday morning, it's Curtis Rogers. I am on with attorney representing Ebony Parker. Ladies and gentlemen, you have heard that my client, Dr. Parker, is accused of the crime of felony charges.
Okay, he's going to need a boost. So let me. His name is Curtis Rogers, the defense attorney. Let's boost him a bit, shall we? Because I can't hear it. I don't know if you can. It might be a little distorted, but that's just the nature of the boost.
Ladies and gentlemen, you have heard that my client, Dr. Parker, is accused of the crime of felony charges and direct. There is one thought that I want you to keep in the forefront of your mind during the this trial. And that is based on their actions, it wasn't a gun. Based on their actions, it wasn't a gun. Now, the Commonwealth talks about a lot, and this ongoing crisis, and that Dr. Parker was the only person that had knowledge of the crisis and the authority to act. I would assume that that's not accurate. It's not true. And think about it. Who was the one person that was there from the beginning to the end? And that was the teacher, Ms. Woman. Okay, based on her actions, she did not act as if there was a gun present. So if she thought there was a gun present, then her actions should have been to separate the child, JT, from his classmates, or separate the classmates from JT.
He's saying the teacher should have done something. Abby Zwerner. She's going to be the first witness up.
She didn't do that. There was also another person that had suspicions, and that was in KOVAC. Okay. If she thought that there was a gun, she had the authority to separate JT from his classmates, or initiate a separation of the classmates from JT. That did not occur. Commonwealth mentioned that JT was out on the playground with his classmates, and there were teachers, agents of school, that observed things that were going on and said that caused an alarm. But based on their actions, they did not respond as if there was a crisis or danger to those students. They did not separate JT from his classmates. They did not separate his classmates from JT. So, Commonwealth is saying that only Dr. Parker had authority. Each one of those individuals had the authority to remove those classmates or to remove JT if they thought that those students were presented with any kind of threat or harm or danger. We're at the beginning of this trial, and I need you to understand that right now, Dr. Parker stands presumed to be innocent. Right now, she's innocent. The Commonwealth has to prove beyond a reasonable doubt that she's guilty of the allegations that they have presumed. The Commonwealth has to prove that Dr. Parker was a guardian, other person responsible for the care of the alleged victims. Before Dr. Parker, there was the teacher, Ms. Zwerner. And the Commonwealth has to prove that Dr. Parker's willful act or omission in the care of the children was so gross, wanton, and culpable as to show a reckless disregard for human life. Who was the person that saw these events from beginning to end? That was the teacher, Ms. Zwerner. Who was another person that pretty much saw everything before Dr. Parker was? That was Ebony Parker, the grievance specialist. There was another person that saw everything from definitely before the shop report, and that's Mr. Ross. If the Commonwealth wants to accuse Dr. Parker, what about these other people that had direct contact with this child, JT? It is my belief that the Commonwealth will not be able to prove beyond a reasonable doubt that Dr. Parker is guilty of these crimes. And I will be asking the conclusion of this trial to find Dr. Parker not guilty. Understand, and you can always consider it. Based upon their actions, there was no crisis. There was no gun. Based upon their actions, there was no crisis. There was no gun.
There was no crisis. There was no gun. That's going to be his catchphrase. There was no crisis. There was no gun. His defense is, she's not the only one. She's not the only one who had authority to do this. There were others in the building that had authority. And I think his defense is also, it was never brought to her attention that there was a gun or there may have been a gun. I think that's what he's saying. Although it sounded a lot to me like wah, 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 because it's hard to understand him. And luckily it was a very short opening. I think he's saying she wasn't on notice that there was a gun. Moving on.
Thank you. All right, the bailiff is going to offer you notepads, and then we're going to try to push forward with the first witness. Just give your handling a break. Okay.
Okay, so they're getting notepads after openings because openings are not evidence. And so they're going to get to take notes of the actual evidence, which will be beginning with the first witness. Okay, I'm going to pull it up to the first witness, which I believe is Abby Zwerner.
Stand right in front of that clerk.
Okay, now the boost comes off because they're going to have a microphone at the witness stand. So we're just going to have to keep playing with the sound.
Do you swear or affirm the testimony you're about to give is the truth, the truth, and nothing but the truth?
There's always a cougher and there's always somebody shuffling papers in front of the mic. It's always the way it is.
You can adjust the chair or microphone to answer questions the attorneys may have. You may proceed.
Good morning.
Good morning.
Could you please tell us your name?
My name is Abby Zwerner.
Ms. Werner, I know we talked about this before, but just as a quick reminder, we're not using the names of any children today, okay? I want to ask you, back in January of 2023, how were you employed at that time?
I was working at Richneck Elementary School.
And what did you do there?
I was a first grade teacher.
And is Richneck Elementary School a school that's here in the city of Newport News?
Yes, it is.
How long had you been teaching as of January 2023?
That was, at that point in time, I had been teaching for 2.5 years.
Okay. So you've told us that you were teaching first graders. Roughly how old are first graders?
Around 6.
And how many students, I'm asking only for a rough estimate, but how many students were in your class roughly?
Around 20, maybe more, maybe less.
Sure. I want to talk to you about one particular student who I've identified as JT. Do you know who I'm talking about?
Yes.
On a couple of days before January 6th, was there an incident with JT in your classroom?
Yes, there was.
Now, JT, was he a student in your class regularly? He was your homeroom student?
Yes, he was.
Okay. And so a couple of days before, what incident happened with JT?
On that Wednesday.
JT is the student, the shooter. They're not using his real name. I can't, I mean, there's nothing I can do about the volume. You may need to watch your screen for the captions because my voice and the attorney's voice are going to be the same. Her voice is going to be lower. There's really nothing that I can do about that. Hopefully they fix it, maybe by tomorrow. He said he was putting a wireless mic up there specifically for the TV feed, but it doesn't seem to have worked.
The student had gotten a hold of my cell phone and he had slammed it into the ground.
And can you describe, if you remember, just his demeanor or behavior in the moments before that happened, leading up to it?
He was defiant.
Objection.
Okay, what's the objection?
Just demeanor, 2 days before what happened on January 6th.
Response.
This testimony will reveal that this was reported to Dr. Parker, so it goes to her knowledge.
So he grabbed her cell phone and threw it on the ground 2 days before. Yeah, this might be a good one for earbuds, you guys.
Which means you all can consider, you may proceed, Mr. Jenkins.
So I had asked about his demeanor in just the moments that led up to the phone.
Yes, he was being defiant, saying no back to my directions.
Okay. And so how did he get your phone, if you know?
It was our small reading group time, and my phone had rang across the classroom, my school phone. And when I had gone back to my small reading group table, I saw him with my cell phone.
Okay. And what was he doing? Do you remember how he looked at that moment?
Just very defiant, almost kind of a challenging face.
Okay. After he broke your phone, do you do something about that for him to try to get a consequence, or what happens?
Yes, I immediately bring him to across the hall to my PE teacher, Miss West's classroom.
Okay. And do you know what Miss West did from there? If you don't know, that's all right. But if you know.
I recall that I asked her to use her walkie-talkie to ask for help.
Okay. And do you know what, if anything, what happened to JT as a result of him smashing the phone?
No.
Okay. Was he at school the next day?
No.
And then did he come to school on January 6th?
Yes.
Okay. I want to talk to you then about January 6th of 2023 then, starting in the morning, maybe lunchtime. Did you have some observations about JT at lunch?
I did.
And before you go on, did you end up reporting those observations to Dr. Parker?
Yes. I did.
Okay. Would you just sort of describe to the jury what it was you saw that you ended up reporting?
Yes. Two things had stuck out to me. At the beginning of lunch in the cafeteria, we were standing in the lunch line, and I was approached by another teacher that the student had threatened to beat up one of her students. And so I...
Objection.
Yes, sir.
Sounds like she is testifying as to something somebody else told her.
Okay, so objection, speculation, your response.
Oh, I heard a hearsay.
Yeah, the judge got that wrong. He was objecting to hearsay because she was about to testify as to what somebody else told her, what another teacher told her.
Objection. Is it a hearsay? So to the extent that it's a hearsay objection, we are not offering this for the truth of the matter asserted. The statement is to show Dr. Parker's knowledge of what was told to her, not whether it's true or not.
Sustained. So I think it's permissible hearsay. I'm not sure what exception it falls under. Do you have an exception?
Well, it wouldn't be hearsay if they're not offering it for its truth. So
Then how's it relevant?
it's relevant because it shows Dr. Parker's knowledge.
Which goes to an element of the case.
Yes.
And therefore has to be reliable. So what hearsay exception is that? What case law do you have?
Oh, she's testing him. She's testing him. She's like, you give me the exception to the hearsay rule. Because you're trying to show that Miss Parker, Dr. Parker, knew about it by what somebody told her, which is absolutely hearsay.
Judge, if it is hearsay, if the court's ruling is that it is hearsay, it does not come in.
Okay, and hearsay is common. So you all cannot consider that. Next question.
Thank you, Judge.
That's the right decision.
So, Ms. Werner, I'll back up a little bit. You mentioned that you were were you personally in the cafeteria?
I was.
Okay. And was there anything you personally observed about JT that concerned you?
Yes. I was speaking with a security officer in the cafeteria about something, and at that same time, I witnessed the student was staring her down, very focused on her, and he slowly got up from his seat and ever so slowly approached, still not breaking focus or eye contact at the security officer, and that stuck out to me a lot as well.
Okay. And is it fair to say that you do go to Dr. Parker to report concerns?
I did.
And without telling us what anyone else said, did you relay to her concerns that you had about things you had observed and concerns about that had been told to you by others?
Objection.
I don't know what the objection is.
That would be hearsay also.
That's hearsay also, he's saying. I'll tell you what the defense attorney is saying because he is very hard to hear. Also, I thought there was no security officer in the building. Apparently, she observed the child JT in the cafeteria staring down the security officer. I don't know, did the security officer have to leave? That's interesting.
Did you observe?
She's reporting what she observed. The report is hearsay. It's out of order statement, out of order should not.
Okay, your response, Mr. Jenkins.
I am only offering that she informed Dr. Parker of her concerns and that her concerns were based on both her observations and what others had told her. I am not eliciting what others said to her at all, so it's not hearsay.
Not a statement, just the, okay, so, overruled, ask your question again, you may answer.
All right, so Ms. Werner, did you eventually go speak to Dr. Parker about your concerns?
I did.
And did those concerns include both your observations and what others had said? Don't tell us what the others said, but just did your observation, did you report to her the problem?
Yes.
Okay, tell us what you reported to Dr. Parker.
Your Honor, I'm going to continue my objection because his question was what she observed and what others said. Now he's going to ask her what you reported, and so she's reporting, sounds like hearsay.
Response.
Judge, she is reporting to Dr. Parker concerns she has based on a totality of things that include what others have said to her. I'm not eliciting what others said to her. I am eliciting what she told Dr. Parker. That is what the testimony is. So this is not hearsay. I am not offering the statement of those individuals at all. Even if I was, I wouldn't be offering it for its truth. I'm offering it for Dr. Parker's reaction to her response. So it is not being offered for its truth. It's being offered for her state of mind.
So I'm going to sustain in part and overrule in part. Again, if the hearsay can't come in through the front door, it then cannot come in through the back door by her saying, well, this is what I told her based upon what other people told me. So she can answer your question as to what she told Dr. Parker based upon her personal knowledge and personal observations, but she cannot relay what she told her based upon what other people told her. So you can proceed that way.
I don't know any other way to ask this, but what did you tell Dr. Parker?
I told her specifically that the student seemed to be off already that day and in a violent mood.
Okay.
If you didn't hear that, she says she's told Dr. Parker that he seemed to be off that day and in a violent mood.
At some point during the course of the day, did anyone suggest to you that that same student, JT, might have a gun?
Yes.
Objection, hearsay.
Okay, objection, hearsay, and maybe foundation. Your response, Mr. Jenkins.
So there are, first of all, that also is not being offered for its truth. We're not offering it to prove that JT had a firearm. We're offering it to prove that someone informed her of a danger. So it's for her response.
So can you lay a better foundation as to how she would have this knowledge?
Sure. During the course of the day, did you become aware that a child was armed?
Yes.
And is that because someone told you the child was armed?
Yes.
Who told you that?
Our reading specialist, Amy KOVAC.
Your Honor, I'm sorry. I was distracted. You asked two questions and I did not hear what those questions were. So I want to make sure that I understand what the questions were. So
Mr. Jenkins, if you would please repeat, or did you ask your co-counsel?
we were actually talking. So.
Okay, he asked, how did you find out he was armed and who told you?
Okay, objection, hearsay.
Okay, go ahead.
At that point, what was your state of mind as to?
Sorry, so that was the question. I did not hear what her response was to that question.
She said Ms. Novak told her. I've got your objections on the record. Overruled. Start your question over again, Mr. Jenkins, please.
Hopefully they get this audio better by tomorrow.
We said, what was your state of mind?
Yes. What was your state of mind as to concerns about that being shared with the administration? Were you going to go share it?
She was like, no, Ms. KOVAC went and told administration.
And
Objection, hearsay.
continued objection noted, you may proceed.
Ms. KOVAC is going to testify next.
And as to that objection, it is overruled, Judge.
It is overruled. Yes,
Thank
you
you.
may proceed.
After that point, were you concerned enough to keep a close eye on JT?
Yes.
Tell us about your observations going forward from there.
Specifically what point in time?
Yeah, so at some point, do you end up, your class goes to recess?
Yes.
Are you there?
Yes.
Okay. What did you observe at that time, if anything, that was concerning?
Yes. I noticed that the student was wearing an oversized jacket with both of his hands in his pockets that remained in his pockets the entire time.
Okay.
And that stuck out to me.
Okay. Did you report that observation to anyone?
I texted Amy KOVAC
Okay.
that observation.
Okay.
Observation was that the student was wearing an oversized jacket and had his hands in his pockets the whole time. That was the observation. And she told that to Ms. KOVAC, who's going to testify next.
After recess, did there come a time when JT and your whole class and you were back in the classroom?
Yes.
And did you observe anything concerning that concerned you when you're back in the classroom that day?
Yes.
Tell us what you observed back in the classroom that started to concern you.
Specifically,
So did you observe JT doing anything that made you concerned after recess time and you're in the classroom? Judge, if I may respond to that.
You may respond.
So a closed-ended question where the witness can answer yes or no is not inherently leading. A leading question is one that suggests one of those two answers is the right answer. I am merely trying to direct the witness to where and when I'm talking about. So in another sense, it is just a preliminary matter. I am not, trying to use it to get a specific answer from her.
Anything further, Mr. T?
Yes, Your Honor, and I think it's been actually been meeting for,
He has, but you didn't check this one, but this one plus bleeding, so I'm going to allow it overruled. But some previous one for a reading, so we'll try to contain that. Do you need him to repeat the question?
yes, please.
Okay. I just want you to describe any concerning observations about JT that happened in your classroom after recess,
If any.
if there are any.
Both hands remained in his pocket, his oversized jacket the entire time.
Was he wearing the jacket in your classroom?
Yes. Did not remove it after recess.
So, Ms. Werner, at some point in the day, were you injured?
Yes.
Tell us what immediately precipitated that. Describe it for us.
Okay, he's already at the part of the shooting. And so far, I haven't heard any testimony that anybody knew that this child had a weapon. He was acting suspicious. 2 days before this, he smashed her cell phone. He didn't come into school the next day. Maybe he was punished at home, or maybe he got a suspension for 1 day for smashing her phone. And then she noticed him glaring at the security officer in the cafeteria. Then at recess, he was wearing an oversized jacket with his hands in the pocket. And same thing happened in the classroom. And then we're already at the shooting. So I didn't hear any evidence right now so far yet that Dr. Parker was on notice that this kid had a gun. Okay. And that's what we're here for. That's what the evidence has to show, that she knew and she did nothing about it and failed to act. And this is the teacher. It's scrolling along the bottom of your screen if you're ever confused and don't know who's on the stand. Also, Law and Crime did a pretty good job with chyrons during this trial, but this is the teacher, also the victim of the shooting. Horrific, horrific accident. Here we go. Accident, intentional act. You know what I mean. Horrific day.
Came to where
I'm taking it back.
Describe it for us.
it came to where I saw at the corner of my eye, my peripheral, the student had. I saw the student looking at me. I looked over a gun was pointed right at me. He was holding a gun, the student, and it was pointed right at me, and then I was shot.
And where on your body did a bullet strike you if it did?
It went through my left hand and into my chest.
What did you do from there?
I recall the children were getting out of the classroom. Miss West was across the hall. She opened her door and was helping the students. And I went to the office.
Okay. At the moment the gun is fired, and I am asking you to estimate how many children were in your classroom. I'm not asking her to speculate about it. I'm asking her to give us a range that it could have been at the time. She doesn't have to guess, she was there.
Nope, that's not them fixing the sound. That's me fixing the sound. I'm going on and off the boost button every time she talks, so that's me, not them. I want all the credit. Here we go.
I would estimate, I would say it's most likely the same as before, but estimate on the lower side, I was missing a couple of students that day. Over 20.
Okay, thank you. You've described the moment where a gun is pointing at you. At that moment, are there any children in your field of vision?
Yes.
Could you describe that?
It's in, the time is in the middle of class, in the middle of a small reading room. So I have students nearby. I also have students at their desks. I have students very close.
Were there any students that were within inches of JT?
Yes.
Were there any students that were between you and JT?
I don't recall.
Okay. May I have a moment, Your Honor?
I can't even imagine how traumatizing it is for this witness, this teacher.
That's all the questions I have for you now. Please answer any questions from the defense counsel.
We're across.
You may.
Thank you. So basically, JT was in your class on January 6th, is that correct? Okay. You reported that he was a little off the chain, being a little violent that morning, is that correct?
He appeared to be off and seemed to be in a violent mood.
Okay. And you had some contact with Ms. KOVAC, is that correct?
Yes.
Okay. And you had contact with Ms. KOVAC before you went out to the playground for recess, is that correct?
Yes.
Okay. And on direct, you said that Ms. KOVAC told you that JT was armed, is that correct?
She told me that the student had told other students that he had brought a gun with him.
That wasn't your testimony on direct. You said that Ms. KOVAC told you that he was armed. That was your testimony, is that correct?
Here today?
Yes.
I said that. No, I'm sorry if I said that. I was specifically told that he was telling other students that he brought a gun with him.
Your Honor, so now I'm going
I
to.
might have heard the question a little differently in my mind.
I know this is the cross-examination, but I'm going to renew my objection to that response because clearly now she's referring to hearsay, and I'm going to ask that her answer to Mr. Jenkins be struck.
Okay. Just how about that response?
Your Honor, this information is being used to show why Ms. Zwerner took the action she did, not being offered for its truth. And hearsay is only hearsay if we're offering it because the statement made is true. So it explains the actions that she took. It is in part a present sense impression if the court is going to rule that it's hearsay, because she's describing a condition that's occurring right now while it is ongoing. And it is being offered to show how they respond to it. Counsel is objecting to me eliciting hearsay and then standing up and eliciting hearsay. And she gave a short answer to me because we were narrowed by the hearsay objection. She was explaining it more fully to counsel now because he asked. So he elicited the hearsay this time. So he can live with that. The rule is that hearsay is an out-of-court statement being offered for its truth. We're not offering any of these statements to prove that JT had a gun. We all know he had a gun. We'll have that testimony.
That's great. Hindsight is also 20/20, sir. You're trying to prosecute a woman because your theory is that she knew or was told that he had a weapon and she failed to act. You can't use, hindsight's 20. We all know he had a gun. This is kind of a mess, Robin. I agree. And it wasn't that he walked her right into hearsay. He was trying to impeach her statement because she says that Ms. KOVAC told me that some other students told her that he might have a gun. It's going to be about who told what to the defendant, Parker, right?
Offering the statements to establish why these people took the actions that they took. That's it. That's not being offered for the truth.
Anything else, Mr. Brown?
I will submit, Your Honor, it is exactly being offered for its truth. Her statement, which I basically just wanted to clarify, her response to his question, she said he was armed. And she wanted to further elaborate. Her elaboration, had she elaborated during the first question, I would have objected. Clearly, hearsay, she's repeating something that somebody else told her, hearsay upon hearsay, Your Honor, and it's definitely being offered for its truth, because there would be no need to respond if there was not a gun.
So for consistent and clear rulings, again, came in before, I'm going to allow the statement in. This is a classic example of why we have cross-examination, and all three attorneys are wonderful attorneys who will flush this out for the jury, and we can have an instruction later, again, that it is not for the truth of the matter, but to explain why the person did what they did. So again, you may continue with your cross-examination, and the jury can consider the response, ultimately, the ruling. The current objection to exclude it based on hearsay is overruled. Please proceed with your cross-examination.
Thank you, Your Honor. So based on information that you received from Ms. KOVAC, you believed that the student was armed, is that correct?
It crossed your mind, yes.
Okay, so it crossed your mind that he had a gun, is that correct?
When I was told what I was told, it was possible.
Okay, so if he was armed, that presented a danger to your students, is that correct?
Yes.
Okay, so you took no action to separate JT from his other classmates, is that correct?
Yes.
All right. And so you allowed him to go out to recess with the understanding that he may have had a gun, is that correct?
Yes.
You could have refused to let him go to recess. You could have removed him from the presence of his other classmates, is that correct?
In hindsight, yes, I could have.
Okay. And then you allowed him to return to your classroom with other students, is that correct?
Yes.
Okay, nothing prevented you from excluding him from the classroom, is that correct?
Yes.
Okay, and nothing prevented you from actually taking JT out of the classroom and taking him down to the administrative office, is that correct?
Yes.
Okay, so on Wednesday, JT was being disruptive, and you did take him out of the classroom, is that correct?
Yes.
Okay, and you also alerted administration, is that correct?
Personally, no.
Okay, but you took steps to make sure that the administration was notified, is that correct?
Personally, no.
You did not take any steps to make? Okay. All right. You would agree that the potential that there's a firearm in the classroom is a lot more serious than JT breaking a cell phone, is that correct?
Yes.
You didn't, once you became concerned, aware of a potential that there being a firearm in JT's possession, you didn't personally let the administration know that I believe that he has a gun. Is that correct?
Correct.
Okay. You personally did not call the police. Is that correct?
Correct.
You personally didn't ask anyone else to remove JT from the classroom. Is that correct?
Correct.
You admit that the person that has the first responsibility to protect the students in the classroom is you as the teacher. Is that correct?
Correct.
And you would admit that you did not take any steps to protect the students from JT, in your words, potentially being armed with a firearm. Is that correct?
I would not admit that.
Okay. What actions did you take to protect the students from JT having a firearm?
This might cross the rules of hearsay, I'm unsure. But from the knowledge that I had that day, I was aware that she was told by
I'm
other
talking about what you did.
Absolutely.
What actions did you take?
Absolutely.
All right. Your response is absolutely?
I'm sorry, what was the question?
Okay. What actions did you personally take to protect the students in your classroom from JT being potentially armed?
I trusted my colleagues.
Okay. All right. You want to have a moment?
You ready?
And while we're doing so, the juror right under that skylight, if you want to move to the empty seat, you can. I apologize. If you're okay to stay, there's nothing I can do without you.
Thank you, Your Honor.
Okay.
I'll get it out.
Okay, all right. I just want to let you know if there is an empty seat that you'd like to move.
Let me ask Your Honor, we ask the defense counsel to speak.
Speak a little loud. We can do that. Thank you. If you follow
Holy.
if you can't hear it, let me know. We can fix that. All right, Mr. Rogers, you heard that instruction.
I did.
Project.
My apologies. I'm a soft talker. So.
Project. He's a low talker. It's a Seinfeld reference. If you know, you know.
All right. Your Honor, that's all the questions I have for this.
Okay. Any replay?
Redirect.
Just briefly, Ms. Werner, while you were at recess, were you observing the student closely? Did you have a belief about someone at that time, while you're at recess, going and reporting the issue?
Objection to leading.
I said, did she have a concern? It is a yes or no question, but that does not make it leading. I'm not suggesting that the answer would be yes or no. I'm just.
Okay, Mr. T, can you flesh out the objection of what part of the question is leading?
What I heard him ask is, if you have an understanding that someone had gone, basically that someone had gone to speak with Dr. Parker while she was at recess. I mean, I think he's leading the testimony there.
And what was your question again, Mr. Chairman?
Did you believe that while you were at recess watching, do you believe that someone was reporting what you were seeing with JT, the concerns about JT?
And that's the question that you're objecting to leading?
Yes, Your Honor, because she has not testified to any such thing. And so he's leading her to actually try to testify on her behalf.
Okay. Overall, I'll allow it, but there may be another objection coming because we need to establish foundation for this belief. Okay, but go ahead for now, Mr. Jenkins, I'll give you some leeway.
Have you told someone that there was an incident that should be reported to Dr. Parker?
Hearsay objection.
So,
Okay, and I understand. Mr. Jenkins saying, well, how can I lay my foundation if he keeps not letting in the hearsay? I'll allow it. Go ahead. It's not the truth of the matter asserted. Truth of the matter asserted. It's explain the actions of why the person takes the actions that they take. Go ahead, Mr. Jenkins.
Ms. Werner, I'm not even asking what you said. I'm merely asking, did you report concerns to another person about JT around the time of recess?
I did directly to KOVAC.
Overrule, but go ahead, repeat your answer. So he asked you, did you report? What was your answer?
I did directly to Amy KOVAC.
And then did you continue to watch JT?
I did.
Okay. What was your understanding of the teacher or faculty member role in the event of an emergency or crisis at that time?
My understanding from it was being brought up to administration. I'm not sure how much what sentence to put that in.
She's afraid of a hearsay objection too.
Ms. Werner, are you worried right now about the rules of evidence and hearsay? Because Okay, I don't want you to worry about that. The judge and the lawyers will worry about that. Okay, you don't have to. All you need to do is give an honest answer. So I'll repeat the question. Okay, what was your understanding of a faculty member's role when you learned of a crisis? What was your understanding of what you were supposed to do? Okay, great. Thank you. I don't have anything further, Judge.
Yes, sir.
But it was also your understanding as a faculty member or teacher that you were responsible for the safety of your children. Is that correct?
Yes.
And that if there was a threat of danger to your students, you were supposed to remove that danger or threat from the presence of the student. Is that correct?
Anything else with this witness?
No, Your Honor.
All right, and does she remain or is she excused?
Your Honor, we're asking that for all of our witnesses, we're asking they be constructively sequestered, told that they need to not discuss the case with anyone, and potentially be recalled, but to be able to leave the courthouse.
Your position.
We've also, she's understood from the defense and we've asked that she remain.
Judge, if I may address that.
Okay.
We have many witnesses here. We don't need to keep them here for all 3 or 4 days. I've told all of the witnesses they're subject to being brought back to court, and I have all of their phone numbers. And if Mr. Rogers wants them to come back, I will cooperate and ensure that they are back here and provide any contact information that's needed. But I don't want to keep people here for 4 days. They don't have to be.
Understood. So almost agreeing to them remain sequestered, but that they can leave the building and they're on call to be brought back. Your position.
That's fine.
That's fine. Okay. All right. So Ms. Warner, those are your instructions. You may step down from the witness stand. You may leave the building, but you may not discuss the case until this trial has concluded. And they have your phone number, so they'll call you when they need you to come back. All right. Thank you very much.
Okay, so this trial's supposed to go, it's supposed to be over by Friday. There are 26 witnesses on the witness list. Let us see the next witness. And they had a little break. And then I believe it's the Miss KOVAC who's going to come in next. This is a criminal trial. If you're confused, there was a civil trial. I understand that Peter Tragos covered it on Lawyer You Know. We did not cover the civil trial. This is the criminal trial. It started today. We're catching up so we can cover it again tomorrow. It's going to be a short one. And this is our filler for Alvin Campbell. This trial we cannot cover because the cameras were pulled out of the Massachusetts courtroom.
Good morning. You can move the microphone if you need to. Okay. And speak any questions the attorney may have.
Okay.
Good morning. Could you please tell us your name?
Amy KOVAC,
Could you spell your last name for us?
KOVAC.
Thank you. Ms. KOVAC, how are you employed as of today?
I work with Newport News Public Schools as a reading specialist at Park.
All right. And then I want to take you back to January of 2023. Were you also a reading specialist at that time?
Yes,
And where were you working?
Richneck Elementary.
How long have you been employed as a reading specialist total?
12 years total.
During your time at Richneck, did you know a student, and I'll remind you that we're not using any student names, so please keep that in mind, but did you know a student by the initials of JT?
Yes, I did.
How did you come to know JT?
Dr. Parker at the time had put him on a modified schedule, and I was his one-on-one teacher for reading during that scheduled time.
Okay. Do you know from your own observations and interactions why JT was on a modified schedule?
I had heard he had,
Here, sir.
I was on a
Hold on
modified.
one second. And how this works procedure-wise is they object, the other party gets to respond, and then I'll make a legal ruling, and then I'll let you know what to do. So, and just explain it to you. Okay, so defense is objected, your response, Mr.
Your Honor, if there is hearsay there, I'm not trying to elicit that, so I'll try to rephrase the question. Ms. KOVAC, did you have any personal interactions with JT yourself that led you to believe that he needed a modified schedule?
Not before the modified schedule.
Okay, understood. So you started working with him in a modified schedule. When was that?
It was in early October.
And tell us a little bit about how the schedule worked.
So originally the schedule, he would come to school at 9:20, get off the bus, and our counselor, Ms. Rawls, at the time would pick him up off of the bus and get him breakfast and set a goal for his day. And then he went down to Mary McBurnett, our K2 special ed teacher, where she was to do a social story. And then he was to come to me around 9:30 or 9:45, and for like 15, 20 minutes do reading with me. And then Mr. Rawls would take him into Ms. Warner's classroom. And then he would leave around, I think, like 10:40, 10:45, get his lunch and then go home.
And you've mentioned Mr. Rawls. Do you know what his title was there?
He was the school counselor.
Okay, thank you. I want to speak to you about the morning of January 6, 2023. Did there come a time when you were in the office that day with Abigail Zwerner and Dr. Parker?
Yes.
And while you were in that office, did you, based on what you heard in that office, did you have concerns?
Yes.
Okay. Later in the day, did you tell Ms. Zwerner to keep an eye on JT?
Yes.
Why?
Because 2 girls had reported to me that he had a gun in his bag.
Okay, what's your objection?
May I lay a foundation for potential use of an exception, Judge? You've indicated, I believe, that 2 girls spoke to you. We'll hold off on what they told you. Can you describe those girls' demeanor or behavior at the time they're reporting it to you?
Yes, I was walking past the room and the 2 little girls had come out to me and said that JT.
Oh, wait, hold on. Before you tell us what they said, what I want to know is how they appeared to
They
you.
seemed to be scared and worried.
Okay, what did you see in them, what in their bodies or their faces that made you think that?
The actions of them coming close to me, wanting to get my full attention and to let me know, and their faces were kind of like expressive to show worry and concern.
Okay, and eventually they do tell you something, again, without going into what they said. Do they relate to you about something that has just happened, that they've just seen in the minutes before? This is to establish a foundation to use a hearsay exception, Judge. It's foundation.
Okay. Hold off on answering. Let me hear the full question, then I can decide on the objection.
Yes, the question is whether the report she receives is quick in time to when she received it. In other words, whether they are reporting something that happened within the last minute, because that's a foundational question for the excited utterance exception.
Mr. T.
I think that's clearly leading. He's asking for, she has not even testified anything about what they said or how, she testified that they seemed scared or whatever, but he's giving her the answer by asking that her, if they tell you something that had just happened right before you get in contact with them. I mean, that's his testifying to the witness.
Okay, let me pull out the excited utterance.
Rule 2803-2.
She's going to pull out the statute. This entire case pretty much is based on hearsay. I'm going to fast forward this a bit.
Made by a declarant with firsthand knowledge at a time and under circumstances.
She's going to tell us what an excited utterance is. Here you go. In case you're wondering, here you go.
Rule 2803 of the Rules of the Supreme Court of Virginia reads, excited utterance, a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at a time and under circumstances negating deliberation. All right, Mr. Jenkins, I'm going to have to sustain the objection because she's not the declarant according to the rules. The declarant would be reportedly that child.
Judge, could we address this matter outside the presence of the jury, please?
We can't want to be in the jury room or side or how
It's like, Your Honor, how am I going to prove my
address it on
case
the
if I
record?
can't get in all
It
this
doesn't-
hearsay? Praise be for those 2 little 6-year-old girls who saw something and said something to Ms. KOVAC, who seems like a very kind reading specialist. Okay.
Matter.
Okay, so members of the jury.
All right. So we're going to go outside the presence of the jury. We're not going to watch this because we're only going to watch what the jury gets to see. So we're going to wait until Ms. K gets back on the stand, and here she comes. She's got her best florals out today. Love it.
When we left off, you were telling us about 2 girls running up to you. Could you please tell us what they said?
They said that JT had a gun in the bag.
Okay. So upon saying that JT had a gun in the back, could you describe their demeanor in saying that?
They came up to me, they were kind of, like nervous and worried and wanted help.
Okay, I think that lays the foundation for her to say what the girls told her under the excited utterance.
Well, I'm not really sure what happened there, but the cameras went off.
You don't know, okay.
And it looks like that was a proffer outside the presence of the jury.
As far as you know, someone could have told him that, correct?
I don't know.
Okay. Your Honor, just based on that, I believe that this is, again, that she has no,
I think we're going to have to fast forward to when the jury comes back, because this was a proffer. If those of you who did watch the trial earlier, outside of spoilers, if you can just tell me, the jury's outside the room, right? Let me wait until they come back in. Because they're still arguing. And this is what this is why it's difficult to argue in front of a witness. Because when you argue in front of the witness, you're sort of giving the witness the answer that you want them to give. And it's also, we saw that a lot in the Edric Foss trial, a lot. The witnesses were on the stand for all of the arguments. Okay, so we are, she says she's going to allow it in. All right, so the jury's coming back now. Now let's see, we're going to get to skip through a lot of the trial today, so that tomorrow we will, maybe we'll start late, so we'll have time to fast forward through a lot of this stuff, including lunch break. You guys let me know what you think about tomorrow covering the trial, because she does tell the jury to come back at 9 a.m. Eastern. Maybe if we start around 10 or 11, we can skip through all the breaks. Thank you, Christy McLaughlin, says the jury's out.
We took the break. We had spoken about, the question was, what made you warn Dr. Parker, right? And do you remember answering about what did? Let me ask you that. What made you warn?
Stop helping her.
There's been no testimony. I believe you just said warn Dr. Parker. There's been no testimony of that nature.
I'm sorry. I apologize, Judge. Let me withdraw that. That's correct. I need to rephrase that question. That's correct about that. The question was, at some point later, do you tell Mrs. Werner to keep an eye on JT? Did you?
Yes.
Okay. And what happened to make you give that warning to Mrs. Werner?
So the girls had reported to me, had come up to me as I was passing right after they came in to say that he had a gun in the bag.
Okay, so this was allowed as an exception to the hearsay rule called excited utterance, because whatever the girls were telling her was an excited utterance. They were so, it was in the spur of the moment. It happened very close in time to when they suspected that he had a gun. And so it's not offered to say he actually did have a gun. It's offered to say that these girls were really afraid. Their state of mind was such that they came to an administrator, they came to the teacher, the reading specialist, to tell her that he may have had a gun. That's why there's an exception here. That's why she's allowing it in.
And the girls had reported to me, had come up to me as I was passing right after they came in to say that he had a gun in the bag. And I went into that room with the children and to him to try and see what he would say, to see if I could help and figure out what was going on, because him and I had a good relationship due to the modified schedule.
Okay. And without telling us what you or he said, did you at that stage get any information about a gun out of him?
I told him the rules of school, that we cannot have any guns in school. We cannot have any type of weapon in school. And I asked him if he had a gun in the bag.
She's very calm.
We went on with the lesson. He was acting very weird that day, out of character, balled up. I just sat quietly by him. His bag was by him. I said, give me that bag. He said, no one is going to touch that bag, which was very out of character.
He's 6.
He also was talking about.
He's 6. It was very out of character. He said, no one's going to touch that bag. He's 6 years old. Taking that back a second. Hope I'm doing all right with the boost and non-boost, because the attorney's loud, she's soft. Trying to even it out for you. I don't even know if I'm doing a good job or not, but hopefully.
Bag was by him. I said, give me that bag. He said, no one is going to touch that bag, which was very out of character. He also was talking about one of his friends at the time.
You're not here's your objections to what you testified as well, what JT may have said.
So same thing as kind of the narrative. You guys know the question.
I can. Thank you, Judge. After you had observed these things with JT, did you talk to Dr. Parker?
Not at that moment.
Okay. What did you do as a result of what you observed?
So what I observed is it was time for them to do their assignment. And so JT asked for some school supplies. So I went up to Ms. Warner and I said, he needs these school supplies. And I asked her when recess was, and I would be back when recess was, and I was going to check that back.
I see. At that point, did you go and speak with Dr. Parker?
Yes, I did. At that point, I left the room right away and went to Dr. Parker's office. And I reported.
Hold on just a minute. At the time that you go to Dr. Parker's office, do you know what Ms. Werner's class was going to do?
They were going to head to recess.
Okay. And when you went to Dr. Parker's office, what did you tell Dr. Parker?
Well, I'm going to let her say, I believe it's going to be a statement that's going to be offered for its truth.
Absolutely not. It's being offered for the fact that Dr. Parker was given the warning, not for whether the warning itself is true. It's not being offered to show that there is a gun. It's being offered to show that Dr. Parker was told there was a gun.
Mr. Rogers, anything further?
Again, the truth that there was, that's what he's saying, there was notice, that's a very important fact issue in the trial. So Dr. Parker, for the truth of there was a warning.
Mr. Jenkins.
I am offering it for the truth that there was a warning. I mean, absolutely. But I'm not offering it to prove there was a gun. And also, Judge, it's a present sense impression. If the court were to find that it's hearsay, which I certainly would argue that it is not, it's also a present sense impression. It's an excited utterance for that matter. It's not offered to prove the fact that there was a gun. It's offered to prove that she was told there was a gun.
That's a huge issue. The notice is a huge issue. Yep. I think the judge is looking at the rules, trying to find an exception for him. I do agree with him. I do agree. It's not offered for the truth that there was a gun. It's a notice issue. That's what she was told, and she should have done something about it, whether it was true or not, right?
Judge, if I could direct the court to a particular rule and section.
You may.
2801, subsection C,
Again, the jury's in the room.
which reads, hearsay is a statement other than one made by the declarant while testifying at trial or hearing that is offered to prove the truth of the matter asserted. So this does not meet the definition of hearsay for two reasons. First, we are not offering it to prove the truth of the matter asserted. And second, the declarant is testifying at the trial. The declarant in this case is Ms. KOVAC.
Tell me if you're on the jury, are you getting annoyed with all of these objections? I don't know. Some people might be like interested in what the law is.
Your Honor, I'll say, hearsay is a statement other than one made by the declarant while testifying at trial. Anything that was said outside of her statement on the stand is a statement other than while testifying at trial. So if she said something to Dr. Parker that's other than while testifying at trial, she can testify as to what she observed, but she cannot testify as to something that she said to somebody else.
So the court's ruling is that it is admissible. There is an exception to hearsay, not only under Rule 2:801, but under Rule, because here's something hearsay, is what the children told her that she didn't blaze the matter. So under 2:805, hearsay is in hearsay. It's not excluded if each part of the statement can come in under another exception. So the children's statement comes in under the excited utterance, so therefore it can come in as hearsay. So I will overrule the objection, which means the jury can consider the response. Repeat your question, Mr. Jason.
Very simply, what did you say to Dr.
Oops.
Parker?
I went to Dr. Parker and I told her that two girls came to me and said that JT had a gun in the bag. And I told her that, that's what I told her, that I was warned that he had a gun in the bag. I told her what I did in the classroom, that I sat in the classroom with him, that he was acting very weird that day, out of character.
Okay, and so you relayed that information to her. Is ultimately, was there a discussion about any additional action that would take place related to the bag?
I told her that when they go to recess, that I was gonna go back and check the bag.
Okay, did Dr. Parker respond to that?
She just acknowledged it with like a nod.
Okay, all right. So what did you go check the bag?
At that point, I left. We were doing makeup state testing, so I went to my office, which is past Ms. Warner's room. And Ms. Warner had texted me at that point.
Okay, I'm gonna have you hold off right there. So just jump with me. Okay, did you at some point go to the room?
Yes.
Okay, and
Yes.
what did you do?
When they were at recess, I went back to the room. I checked his bag. Inside his bag was a puzzle, a math book, a little coin token, and then a calculator in the front pocket.
Okay.
So she did go search his bag. She did. She doesn't care what the rules are. She's like, I don't care if I'm not the one allowed to search his bag. I don't care if the only one allowed to search the bag is the principal, assistant principal, or the school resource officer or security guard. I'm doing it. She did it. Good on Miss KOVAC. Unfortunately, the gun wasn't there. Let's hear it again. Because they were at recess and maybe it was in his coat. Were they at recess at this point? I think that's what she said. Hold on.
And Ms. Warner had texted me at that point.
Okay, I'm gonna have you hold off right there. So just jump with me. Okay, did you at some point go to the room?
Yes.
Okay, and
Yes.
what did you do?
When they were at recess, I went back to the room. I checked his bag. Inside his bag was a puzzle, a math book, a little coin token, and then a calculator in the front pocket.
Okay, and what happened next?
But we heard the teacher say, Abby Zwerner, who is the one who was shot, that she noticed at recess that he had his hands in his coat, in his big oversized coat, and that, see, the timeline is this is recess. Recess is what Abby testified about before. He had a big coat on and his hands were in his pocket the whole time. This happened before recess because during recess is when she takes it upon herself to go search the bag. Okay.
After I checked the bag, I went back to Dr. Parker's office to let her know that I checked that bag. I told her the same items that were in the bag that I had seen.
Okay, and what did you do next?
After that, I went back and I went back outside to Abby and the class that was outside at recess.
Okay, I'm going to pause you right there. While you're outside at recess, without saying what anyone said, were there discussions among the teachers?
There was only her outside with her class at that time, and then I came outside at that time.
Did you and Abby talk?
Yes.
And had you and Ms. Werner, again, without saying what the content was, had you and Ms. Werner also communicated by text message?
Yes.
Okay. Now, as a result of those communications, again, it doesn't matter what was said. What did you do next?
So, from the result of the text, I then went and checked the bag. I then went and reported a second time to Dr. Parker. Then I went outside to speak to Abby to see if he would come to me because of what she had said in the text. So he was behind the rock wall, did not come to me. And then I told her again.
But wait, you told who?
I told Abby.
Okay. Are there two conversations with Dr. Parker?
There were two times I reported, and then one time I was in the office. And then Dr. Parker had told me that I could tell Abby an action to do if he misbehaved.
Okay. What prompted the first time you talked to Dr. Parker briefly?
The report of the gun.
From the girls?
Correct.
Okay. Briefly, what prompted the second time you talked to Dr. Parker?
The message that I received.
Understood. In the second conversation with Dr. Parker, what did you advise her of?
I advised her that the weapon in discussion was now in his jacket pocket.
And that was your belief?
That was my belief.
Okay. You mentioned that you had been at recess. At recess, did you have an opportunity to see JT?
I did not.
Okay.
She just said she went out to recess and he was behind the rock wall. She tried to get him to come out, but he didn't come out. Did she see him or she didn't see him? She just said she didn't see him. Okay.
according to your understanding at the time, what was the protocol for teachers or faculty members to follow when they believed there was some sort of crisis developing?
According to the Richneck handbook, we were to report to our administrators.
Hold on.
We were to report to our administrators.
Anybody think she's got the handbook memorized? I do.
No, I'm going to object. Hearsay, talking about something in the handbook, it's not true.
Response.
I just asked if she knew it, and it is knowledge that she had. She's not reading from anything. She doesn't have the handbook, so she's just saying that she has that knowledge of the policy.
I will have to answer both ways.
Ms. Kovac, I want to take you to the moment on January 6th that a gunshot has happened. Do you recall that moment?
Yes.
Okay. And
From this moment forward on direct, everything that they're going to talk about, I imagine, is what happened after the gunshot. So we heard her say she went into Parker twice, right? Told Parker she was going to search the backpack, which she did. She didn't find anything. Then she's texting with Abby Zwerner. And then she never saw him in the yard. And now she knows that underneath the handbook, she's supposed to report it to the administrator. And now we're going to go from the gunshot, from the event, the shooting forward. Here we go.
what was your first thought and what did you do?
My first thought was, he had a gun, he shot it, and I walked in that room. He hit me
In that room,
in Abby's room, room 11.
okay.
He
And-
hit me.
Okay, hold on. Let me walk you through it. When you walk into the room, what do you see?
I walk into the room, Abby is to my left, and I see blood on her leg, so I know she was hit. To my right, the children are running out and screaming, going across to the hall to the open door. And he was standing right in front of me, arms crossed, legs spread, and cocky.
Okay. At that stage, do you see a gun anywhere?
I do. It's on the left, my left, slightly under the reading table.
Did you go to justice? I'm sorry, JP.
I went straight to him. He did not resist me. I took him by the wrist because I knew he shot left-handed. He's left-handed. I didn't want to ruin the gunpowder, watched enough shows. I took him to the front of the room. I sat in Abby's
Did she say she watches enough shows that she didn't want to disrupt the gunpowder on his hand? And she knows that he shoots left hand because she watches a lot of true crime. Wait a minute. Hold on. I mean, good on her. Good on her, right? She sees the weapons not in his, she gets stuff done. I can tell you this woman gets stuff done. And she probably blames herself every single day that she didn't do more to prevent this from happening, right? She will never, this event is ingrained in her memory forever. Let's hear her tell us again what she did after hearing the gunshot.
I took him by the wrist because I did straight to him.
Did you go to justice? I'm sorry, JP.
I went straight to him. He did not resist me. I took him by the wrist because I knew he shot left-handed. He's left-handed. I didn't want to ruin the gunpowder, watched enough shows. I took him to the front of the room. I sat in
I've watched enough shows, she said.
Abby's chair. I put him in between my legs and my arms, and I picked up and I called 911.
Okay. And then after you did that, do police eventually arrive?
Eventually, it felt like eternity.
Yeah. So when they arrive, what position are you in? Are you still that same?
I'm still in that same position. So we were facing, the phone is here, and we were facing as the police were coming in.
Okay. And as the police are coming in to the room, what is going on with JT? What is he doing?
It's relevant at this point. It's not relevant to these proceedings at this point. What happened after the gunshot, or whether Dr. Parker is guilty of anything. We've gone beyond what's in this communication with the police.
Your Honor, the statute contemplates the event. I'm sorry, there couldn't be anything more relevant. The event of the shooting and its immediate aftermath is precisely what Dr. Parker is charged with. The effect of her omission is what we're hearing right now. And so this is the very circumstance. It is the immediate shooting and its aftermath, and its after effects for these children. And what she's describing is a present sense impression of something that is occurring as it's occurring.
So I will overrule the objection in terms of it's part of the incident and the immediate aftermath. Now the ongoing effects, there are going to be some limits on that. We can't talk about, I don't expect to talk about things more than 2 hours after this incident. Are you going past that?
Not with this witness, Judge, but with children and families that experienced ongoing effects from the neglect, but not with this witness.
And we'll take that up at a later point. But yes, you may continue with this witness. Objection overruled.
When police arrive, that's the part we're talking about. What is JT doing?
He is in my arms, and they asked me if, I was okay, and if he was okay, and we were both okay. He became more agitated and cussing up a storm. And eventually, he was just spewing cuss words, stating, that he.
No, I'm going to again object to relevance here. And also the fact that this testimony is really more prejudicial than probative of any element of the offense.
So your response?
I think the court has already ruled on that.
We did talk about prejudicial versus probative. You want to respond to that portion of the objection? That's a new objection.
Sure. All of the Commonwealth's evidence is prejudicial by definition. The question is whether it is probative. Probative is another word for relevant. Dr. Parker is charged with neglect of children that caused a shooting, and the testimony is about the shooting and its immediate after effects while there is still a gun on the floor, while police are arriving. So it is relevant, it is probative, highly probative, and therefore admissible.
So to the two-part objection from the defense, the court overrules it. The first part I previously ruled, so I note your continuing objection. As to the second part, prejudicial versus probative, it has to be, I think, substantially outweighed according to the admissibility standards in this case. Therefore, I rule it. I'm going to allow the testimony. You may consider it. Do you need him to repeat the question?
No.
Okay, you may finish your answer.
Okay, he was in my arms, he was getting agitated, he was cussing. I told him Mrs. KOVAC does not like that language. He turned, gave me the finger, and then when I turned my head back, he punched me. My glasses went off, and I said that I was done, and I turned him over to the police.
Okay.
Ms. KOVAC does not like that language. Don't curse at me. Wow. I mean, this woman kept her cool. I don't know that I would have been able to do that. Do you? MF says, as someone who works in a public school with behavioral students, I would have no problem at all breaking policy if I suspected a pew-pew in a student's backpack. Screw policy at that point. Thanks for your 10. Kelly, sorry, this was about an hour ago. Kelly said, could have insisted Dr. P checked themselves, gone to the principal, or took JT to Dr. P's office. Plenty of options that didn't leave him with other kids. Thank you, Kelly, for tuning in from across the pond. Dolo says, I've been watching you forever. Finally, a member, long overdue. Love me some Melanie. Oh, thank you for your 5, Dolo. Appreciate you so much. Michigan, thanks for being here for 3 months. And Gigi's here. Thanks for your 20. Gigi says, hi, Cupcakes. Mods and Melanie, I'm watching on TV. Back to the doctor tomorrow. Watching this trial makes me miss Lally saying, what, if anything? Save that hearsay button for the defense. Miss all of you. I hope your shoulder replacement's going well, Gigi. We love you so much. Thanks for your 20. I'm glad you're able to watch. We're able to keep you company on your road to recovery. Let's keep going.
At that point, did you leave the room?
At that point, I did leave the room.
Okay, thank you. Now, Ms. KOVAC, if you know, were police wearing body cameras while they were in there that day?
I knew that the one police officer said that he had the body cam on and got the whole transaction and my assault on the body cam.
If I were to show you a still picture from that, would you be able to recognize yourself and JT?
Yes.
Judge, I'm going to ask permission to show that to the witness at this time.
Okay.
Is this still photo from the body cam?
Lay it on the television.
First, I'm going to show it to defense counsel, then approach the witness stand until I've laid a foundation to show it.
Oh, yes, sir. Thank you.
All right, if everyone can
Take a look at that.
hit the like button, that'd be great. Thank you.
Just going to ask you to take a look at that. Can you see it clearly?
Yes.
I'm going to return and ask you some questions.
Okay.
Ms. KOVAC, having had a chance to look at that still frame, does it depict you in the exact setting and circumstances that you've just testified to?
Yes,
Does it appear to you to be a fair and accurate representation as a still of a moment of that interaction you just described?
yes.
All right. Judge, I am going to move to admit this into evidence as Commonwealth's 1. It is a video that is approximately 2 minutes and 51 seconds. It depicts the things about which she has testified.
She's not in the video. She was showing effectively a picture that showed her sitting with this child in her arms. There's no way, based on that, just seeing a picture, that she can properly authenticate that video. So what we need to do is exclude the jury, let her see the video, and then she can testify that what that video portrays.
He's right.
Right now, just based on the picture, that doesn't indicate what that is, but it doesn't indicate the video.
Additionally, Your Honor, I believe the video is cumulative. And again, it's just shown to prejudice Dr. Parker. It's the prejudicial value substantially outweighs any probative value that a video is actually have.
I'll address the first one. It sounds like it's an authentication objection. I was hoping we would avoid sending the jury out, but counsel is right. If we, to authenticate the video, I need to show her the video and let her authenticate it. So.
Oh, yes, you said still photograph.
That's right.
We're talking about 2 minutes and 51 seconds. But I mean, if you could just play it without the volume, if that's adequate, I don't know, then she can just watch it in the witness stand before we publish it.
Yes, without the audio for her purposes.
But yes, if that's sufficient for authentication, and again, I don't know, I haven't seen it.
That's sufficient for me.
Okay.
I don't know.
And then what was the second objection, prejudice versus probative?
And cumulative, Your Honor.
His objection was that she can't authenticate this screenshot as being from the video unless she watches the video, and he's right. And the prosecutor knew that, so why didn't he just have her watch the video first? And then he says it's more prejudicial than probative. We don't know. I guess he knows what the screenshot is going to look like. But Noni's Treasure House, I'm glad you put this back in the chat because it flew by before and I didn't get a chance to put it up. But Noni says the problem here is the fact that they don't have good, reasonable, common sense policies, right? This is trial day 1 from earlier today. It is 6 o'clock in Virginia. We are rewatching the testimony from today because I did not watch it with you guys at all. And I got FOMO and I thought that this was an important trial to follow. So we are zooming through today's testimony so we can pick it up live tomorrow, but maybe on a little bit of a delay. The media feed is on a half an hour delay, and we'll decide later at the end of the stream what we're going to do about this tomorrow. If you did watch the civil trial, maybe just keep it to yourself until the end, and we'll talk about all the things at the end of this case. We'll talk about all the things that came into the civil trial and the way it was different than what we're hearing during the criminal trial. I did not watch the civil trial. And so for me, as I've explained at the beginning of this case, I'm a civil litigator. The burden in civil court is much, much lower. The rules of evidence are much more generous. Almost everything comes in at a civil trial, okay? Here we have a person who's on trial at a criminal trial. And so the burden is on the prosecution to prove this case beyond a reasonable doubt, not just by a preponderance or the evidence of 51% or more. It is a very, very, very different trial than what happened at the civil trial. And so what we're trying to do is watch only the parts of this trial that the jury is going to see. Anything that is argued outside the presence of the jury, we're trying to fast forward through it because this is a very important issue. We have seen parents tried for their child who gets a gun from inside the house and then goes and does a school shooting. The mother in this case is, I think somebody just said she just got out yesterday, but she served something like 4 years. Okay, she pled guilty. The mother has been punished in this case. The child said he climbed up onto a high dresser and got it out of her purse. It was a legal firearm. Timothy Shortstack said the mom took a plea deal and got out last week on the 13th. She got 21 months for owning a firearm, and Mary Jane, and 2 years for child neglect. And the date of this incident was January 6, 2023. So the mom did a little over 3 years, and she's, well, depending on when she took her plea, I don't know. I don't know exactly how much time she did. I'd like receipts on that because I'm going to take your word for it. I'm going to take your word for it. Dennis says, is that normal that an attorney interrupts and asks for the previous questions because he wasn't paying attention? Yeah, it is. You can get sidetracked. You can ask for a readback as an attorney. You have the right to represent your client as zealously as possible. And so it is not uncommon that you get sidetracked doing 14 other things and you want to hear the question again. Totally fine. It's totally fine. It is not improper. And Zoe pointing out, I guess there was some chatter in the chat about the Crumbly incident, which I think is a lot different than this. And Zoe said, I think Crumbly incident is different because school administrators and teachers removed him from class, called the parents and asked them to remove the child from school, and they refused. That was also a prosecution of the parents. The school administrators were never charged in the Crumbly case, right? And also, they did at one point have possession of that backpack in the Crumbly incident. They also knew about all the crazy drawings the kid was making and stuff, right? And they didn't notify the parents. Also, the backpack was in the principal's office or the assistant principal's office, and they did not search it. And the school administrators in Crumbly were never charged, to my knowledge, correct? Still criminally. This whole case is very disturbing in many ways. Max Bang said, it's been a fantastic day for us. We prosecuted the person who tried to extort $250,000 from your 84-year-old mom. Well, were they found guilty? Thanks to your 10. I don't really know what you're saying, but I'm glad it was a fantastic day for you, Max Bang. And thank you for paying me $10 to report on it. Thank you. Noni McGee's mom is Noni McGee's husband is a Newport News police officer. Worlds colliding. It is. Thank you very much. And thank you so very much to Martina for your New Zealand super chat and for saying I was awesome on Turtle Boys fundraiser. I appreciate you so much. Okay, let's keep going with this. See how much we can get through today.
I didn't hear you.
Cumulative.
Cumulative. Okay. So I overruled on both of those, and Mr. Jenkins, are you able to play it?
Yes, Your Honor.
And so again, he's going to approach and play it pretty silently. Yes, ma'am.
We're still having trouble here.
Still having trouble hearing them. Okay. Mr. Rogers, I don't have a microphone. I don't know what we can do. They still can't hear you.
Nobody ever has trouble hearing me.
The civil proceeding is over. Abby Zwerner sued Dr. Parker and got a $10 million jury verdict back in November. So Abby has sued this defendant. She got a $10 million verdict, which has stayed pending post-trial motions or an appeal or something. I don't think she's collected anything. But this is the criminal trial of the Commonwealth of Virginia against Dr. Parker for her failure to act. She is facing up to 40 years on 8 counts of felony child neglect, 1 count for each of the bullets the child brought to school that day. 8 counts. Here we go. We're going to fast forward this because she's going to watch the video.
8 counts of abuse and neglect of children. What happened Ms. Warner described it. And the behavior that Ms. KOVAC had to endure on that one after this shooting event, that was tragic also. But I believe she testified that the shot was fired. She turned around and went to the room, and as she was going into the room, the children were leaving the room.
What's your objection?
There were no children present. They weren't at the moment that she's about to testify. There were no children that were subject to abuse and neglect.
This sounds like a motion strike, so I'll hear that too. Okay.
I'm going to keep scooching.
Ms. KOVAC, you've just watched a video. I'm sorry, is that yes?
Yes, sorry.
Thank you. Does that video fairly and accurately show what happened in those moments that you were just describing in your testimony?
Yes, it does.
Judge, I do move the video into evidence as Commonwealth 1.
Defense, already objected, so there's so noted, no proposal, and you may play the video. This will be marked, again, you said Commonwealth 1?
Commonwealth 1, Your Honor. And for the purposes of media coverage of this video, we have muted the name of JT and
Well, now they're muting him. I don't think they're going to show this, right, you guys? Is the video blurred? They're not going to show us the video. I thought he just wanted to admit a screenshot of the video, but now he wants to admit the whole video. So we're going to fast forward. Because we're not going to get to see the video, only the jury will.
envelope labeled KOVAC is ruled to be a Commonwealth 1. It is a USB drive inside a envelope labeled KOVAC JT in classroom. May I approach?
You may, and so marked and so received.
Thank you, Ms. KOVAC. I don't have any more questions for you, but please answer any questions from defense counsel.
Okay, here's going to be cross.
Before I start our cross-examination, can I take a brief recess?
Okay.
Or can I just step out?
Yes, you can step out. We'll just be quiet. Yes, sir.
All right, he needs to use the men's room, I think. So we can fast forward through that.
Okay, so defense ready to proceed with cross-examination?
Yes, ma'am.
All right, please do.
Please find the mics tomorrow, you guys.
Okay. Name is Amy KOVAC,
Yes,
and I believe you testified that you have been a reading specialist for 16 years?
13,
15 years? And how long have you actually been a teacher?
33 years.
A lot of experience in the school system.
Correct.
Is that entire time with Newport News City Schools?
No, the first 10 years were in Queen County. I've been with Newport News for 23 years.
Okay. All right. And would you agree that you had actually spent a lot of time with JT prior to this incident?
On the modified schedule, yes, so from October through January.
So you were used to his ups and downs, is that correct?
Correct.
Okay. He had good days?
Yes, with me.
Okay. And obviously, even prior to this day, he had some bad days.
Correct.
Would you agree that the Wednesday prior, just immediately prior, he had a bad day?
Correct.
Were you there to see and observe his behavior on Wednesday?
In the classroom,
After the classroom incident?
I was in the office when he was brought up.
Okay. All right. And are you aware who brought him up?
Mr. Ross,
Okay. All right. You know why he was brought up?
he didn't tell me then. I called for the buses at that point.
Okay. But you knew there was an incident in the classroom that he was brought.
No, no KPT. It is not one count for each projectile fire. I think he only fired one. There were 7 in the gun. That's the way I understand it. So it is potentially, because there were potentially 8 times that he could have shot the weapon. That is why she's being charged with 8 counts.
Out of the classroom, is that correct?
I knew that he was in an incident and was carried to the office.
Okay. All right. Okay. Good. All right. So would you agree that it's the teacher's responsibility, primary responsibility, to make sure that the students in their classrooms are safe and protected from any harm?
It is the teacher's responsibility to teach the children, to have a schedule for the children, and to handle disruptive behavior, not excessive behavior, is my understanding.
Okay. So you would agree that if there's a disruptive student in the classroom, the teacher has the authority to remove that child from the classroom?
She can usually call for help. That's what I would do.
So you're saying no, a teacher cannot remove a student from the classroom for disruptive behavior?
I mean, to another classroom. It just depends on what the classroom plan is and the school's rules are.
So yes or no?
I don't know.
You don't know. Okay. All right. Have you ever removed a student from a classroom for disruptive behavior?
In my classroom as a general ed teacher
Sure.
or as a reading specialist?
A general ed teacher.
Yes, I'd move them to another classroom.
Okay. All right. You would also agree that a teacher has the ability, if a student is disruptive, to take them down to the administrative office.
If there's someone to watch their class if needed.
All right. So obviously, You don't want to assign any blame or responsibility for the classroom teacher for JT's behavior on that day. Is that correct?
Objection. This calls for speculation is an opinion about whether she wants to assign something to somebody.
I'll let the court rule on it.
Cross-examination, he's allowed to forward back the witnesses.
It's not my place. I mean, I don't know, but I can't think for somebody else. I can only think for myself.
Okay. All right. So let's start when you first became aware that there may be a problem with JT. Okay. I believe it was the incident with the 2 young girls. Is that correct?
For that day?
For that day.
No, that was not the first time.
Okay. What was the first time that you had any kind of indication that JT was having a bad day?
When Ms. Warner came in to report that he had been acting up in the lunchroom, and she was reporting to Ms. Parker. Myself and Ms. Harris were in there because it was testing. We had just returned our tickets. Dr. Parker did not look up at her, did not acknowledge her.
Okay. You did not observe this behavior yourself. This was just something.
I did observe that behavior.
What observed? What?
Not just his behavior.
That's what I'm talking about. I'm talking about JT.
But
Oh man, they keep mentioning the child's first name, but we're just going to ignore it. First time was when Abby Zwerner came in and said he's acting out of sorts today, off the chain, is what the defense attorney said. He's trying to show that there are a lot of other people who could have done something, including the classroom teacher, other than his client, Dr. Parker. That's what he's trying to get at here.
Parker and Anna's behavior, I did observe.
Okay. All right. And then you had the encounter with the 2 young girls. Is that correct?
Correct.
All right. And so it sounds like, based on your testimony during direct examination, that you believe the girl's assertion that JT had a gun. Is that correct?
Correct.
Okay. So obviously, if JT had a gun, then he presented a danger to the students in his classroom. Is that correct?
Correct. Correct.
Okay. All right. So you went to investigate that. Is that correct?
I walked into that classroom to speak with him.
With the belief that he had a gun. Is that correct?
With the belief that it was a possible weapon.
Okay. All right. And so, and you observed that he was acting off. Is that correct?
Correct.
Okay. You, along with his teacher, had the authority to remove him from the classroom. Isn't that correct?
We had already told her that the.
I'm talking about your authority. You had the authority, along with Ms. Warner.
I don't know.
Okay. All right. But even with you indicating that you believe that he had a gun, you spent some time with him, and then you left him in the classroom, even though you believe that he had possessed a gun. Is that correct?
I left the classroom to report as required by my school.
If a student had a gun, don't you believe it's required that you separate that student from the other students so he doesn't present a danger or harm to those students?
Objection's been asked and answered 3 times.
Your Honor, I'm just trying to make sure that she clearly indicates what her responsibilities are regarding the safety of the children.
Yes, one last time. For the safety of the children, I did not remove him at that point.
All right. So then you said that you actually spent some time on the playground when JT was with his classmates. Is that correct?
I went out to the playground, did not spend time. I was testing and had to get back.
But you believe that he had a gun on the playground. Isn't that correct?
I'm not sure what kind of gun, I'm not sure what kind of weapon. I had not seen it myself. I only heard the reports and I reported as required.
But you said you believed it was a gun. Is that correct?
Because the girls reported.
And you believed them.
Any report of a weapon in a school, I'm reporting, and I did.
All right.
More than once.
Is there a possibility that you thought it was a toy gun versus a real gun?
I mean, my personal thoughts are my personal thoughts, so.
Did you express to anybody that you thought it was probably a toy and not a real gun?
Yes, after the incident, the police have it on police cam. That was my thoughts while I was in shock.
Oh.
Okay.
She doth explain too
so
much.
You believe there was a real gun, and then you left the other
I
student.
did not know if it was a real gun or not. Right now, I was in the room with him.
So you didn't believe that he had a gun?
Objection, Your Honor. He's misstating her testimony over and over within his questions.
Your Honor, she's trying to have it both ways. She indicated on direct examination that she believed he had a gun. Now that I am assigning her responsibility to her, she's trying to say that, well, I don't know. What I believed at the time, she's acknowledged that she did tell somebody that there was a toy gun. So I'm just trying to narrow down whether or not she believed it was a gun or not.
Okay, your objection.
It's that she has already said the answer. She has already said that it could have been any kind of gun she didn't know. And
But she keeps changing her testimony. He's trying to lock her down, and he's entitled to do that, don't you think? Astro says, I'm a former teacher. I was not able to remove students from my class, even when they were dangerous. I could send them to the office, but if that happened often, I got reprimanded.
he keeps restating her testimony differently than that. He keeps saying, you believed it was a gun. And she keeps saying, I didn't know if it was a gun.
Well, I think he switched to her stating something different reportedly on the body cam that now says toy gun. And again, strong cross-examination, vigorous cross-examination is fundamental of our justice system. So overruled, you may proceed, Mr. Rogers.
Your Honor, may I address one other issue?
Yes.
I'm hearing in the courtroom gallery commentary for coming over my right shoulder. I just think the gallery needs to be informed that they're not.
Okay, and I can do that. And I heard something, I just couldn't tell the direction.
There's commentary coming from over his shoulder in the courtroom. Somebody live streaming and commentating from the gallery. What? She's like, I heard it, but I wasn't sure where it was coming from. Oh, man.
Absolute silence from participants in the courtroom. We cannot comment, we cannot bolster, we cannot suggest our opinions in any way, and please govern yourselves accordingly. This is an open public proceeding, but if people are disruptive, they will be asked to leave. Comments are considered disruptive, and I can't close this courtroom. I'll ask everyone to govern themselves accordingly, and I think the sheriff start keeping an eye out for that when he was. So sheriff, if anybody making noise, please escort them out. Thank you. All right, please proceed, Mr. Rogers.
Thank you, Your Honor. So it sounds like now you're saying that you weren't sure if you possessed a firearm. Is that correct?
What I'm saying is, the girls reported that there was a gun,
And you believe them?
and
Objection, Judge.
Yeah, let her finish her response, Mr. Rogers.
I acted on the report. Children were 6 years old, first grade. I acted on the report. I went to see what was going on with him. I did not look in the bag. I did not touch the bag. I was in the room. When I left the room, I went and reported to my administrator.
Did you leave that?
Are you finished your response? Yeah. Okay, next question.
Did you leave that room believing that there was a gun?
I left that room believing that there was something in that bag.
Something that potentially presented a threat of harm to those children?
This is ask and answer, Mr. Rogers.
All right.
Next question.
All right. All right. And then let's talk about the playground. Same thing, right? You knew that JT was out on the playground, is that correct?
Correct.
All right. You said that you didn't visually see him yourself, but you knew he was present, is that correct?
Correct.
Okay. He was out there with his classmates, is that correct?
Correct.
All right. Miss Zwerner, his teacher was out there, isn't that correct?
Correct.
Okay. There was nothing that prevented you or Miss Zwerner on that playground to separate JT from the rest of his classmates, isn't that correct?
No.
All right. So you said that you searched his backpack, is that correct?
Correct.
Okay. After you searched his backpack, did that dispel any fears that you may have had that he possessed a firearm?
No.
Okay. So you continued to think that he potentially had a firearm, is that correct?
Something. He had some kind of weapon.
When you say some kind of weapon, are we talking, are
We're
you,
still
are you,
talking gun because that's what the girls reported. I did not know what was in that bag.
so are you,
Anything could be a weapon, right? Sherilyn, I agree with you. She says, I'm going to say this once very loudly. Our teachers don't get paid enough for this. Yes, agreed. And there was another comment that flew by here that said, Robin said, does this all come down to the school not wanting to be sued versus common sense? I don't know. The school was sued. So the school was sued. I think the county was sued. Dr. Parker was sued. Everyone was let out of the case in civil court except for Dr. Parker, I believe. If you watch the civil trial, you can let me know. But I believe that I did read that this morning in my shallow dive into this case. So that lawsuit is already concluded with a $10 million jury verdict in favor of Abby Zwerner, the teacher who was shot. The kid's parent was charged, took a plea, spent a little over 3 years in jail. So the parent has been charged. Now Dr. Parker is on trial. This becomes, in my opinion, just from my half a day of testimony that I'm watching here, and you can let me know if you think, if you agree, if you are in the school system, if you work as a teacher or any, because next time the teacher is going to get sued, okay? Or next time the teacher is going to get, criminally charged. This is a slippery slope. It's a slippery slope, in my opinion. Are these charges warranted in this case? I don't know yet. I don't know yet. But the woman who is sitting in the defendant chair is facing up to 40 years in prison for her failure to act, not her actions, her failure to act. The parent has been punished, did some prison time or jail time, and now they're going up to administration. At what point would they have charged the teacher was very sadly and tragically the one who was shot. Thank God she lived. But let's say the student shot another student. Would they have charged Abby Zwerner, the teacher, in that case? Because she had an idea or an inkling that something was off and something was wrong. Do they need to update their policies? I mean, are criminal charges against the school administrator going to, what is that going to solve or change? Or will people think twice? Will people start calling 911? Will they make changes with regard to school security? I have so many questions. I just don't know if this is a slippery slope or not. I thought it was a bit of a slippery slope when we started to charge parents, but it depends on the age of the child, right? So I don't know what the right answer is. I don't know. I genuinely don't know what the right answer is, but it's all things to think about. That's why I wanted to cover this, because I think there's a lot of nuance here. There are a lot of interesting questions. If the child had shot another child in that classroom, would Abby Zwerner be sitting in that defendant's chair? I don't know. I genuinely don't know. Hindsight is always 20/20. I feel like this witness wants to really help Abby and wants to throw Dr. Parker under the bus for whatever reason. And I just don't know. I don't know if she's going to testify in her defense. I believe, did she testify? She did not testify, I think in the civil trial. I don't know. And perhaps, teachers need to have the authority. Perhaps the authority shouldn't just go to like head administration. And then, you're getting into violation of privacy of students if you're searching their backpacks without probable cause and all that kind of stuff. So I don't know what the answer is. And I really just don't know which way I'm going to land on this, if either side, because I can see both sides of this right now, right? I can see she did testify in civil. Tiff, you watched the trial? I would think that she would, but with criminal charges pending, I would think that she wouldn't. And I'm surprised that the civil trial went ahead before the criminal trial. That's something else that is strange to me. And so I just don't know. Does every school need metal detectors for children that are walking in? I don't know. It's an interesting conversation. So let's keep going.
Holding out the possibility that it's a toy gun.
I'm not sure what it was.
Yes or no?
It could have been, yes.
All right. So if it was a toy gun,
We still report and they still investigate.
I got you, but it's not a toy gun is not a threat of harm to the children. Isn't that correct?
If there is a report, it is required by the state that you report.
Do you understand
And
my
did
question?
report. I do.
Ooh, they're getting fiery. Oh, okay. Thank you, Tiff. No, I'm talking about the defendant. I'm talking about the defendant, whether the defendant testified at the civil trial, and you're saying no. I wouldn't think that she would with the criminal case pending. And people are thinking this too. Kraft Hassel was like, it should have stopped with the mother's charges. End of period. Story. End of story. End of story. They are not the police, meaning the administration and the teachers. They're not the police. They are not security. They are not paid enough for this fight. Kraft AMG is saying, I feel like your point, Melanie, is exactly what the jury's thinking. And if the prosecution doesn't make this clearer, this is going to land in a not guilty. And should it? The mother did her time, Whose fault is it that the child wound up in possession of a firearm? It's not the teacher's fault. It's not the principal's fault. It's not the school security officer's fault. These are criminal charges. This, in my opinion, may be better suited in civil court, which is where it went. And Abby got a $10 million verdict. Is this an overcharge in state court? We'll see. I don't know. It's hard to know what to do. And that's why I don't know. I really don't know. We'll see how the evidence comes in. We'll see what evidence comes in. It's going to be very, very different. It's going to look very different than the civil trial. So for those of you who watched it, I'm curious to hear your thoughts at the end of the case. You know, what was different about the civil trial? And if you did watch the civil trial, try and just focus on what's coming into this trial. And if it changes your mind in the end, if right now you're saying guilty, 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 and if at the end of the case you change your mind, seeing how the evidence is going to come into this case differently, or if you're going to stay guilty, 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 or if you're saying, I'm a teacher, I could be promoted to principal someday, or assistant principal, or dean, or I don't want to be held responsible for something like it's very difficult. It's a very, very difficult situation in my opinion. Now she's talking about it might have been a toy. Let's keep going.
You understand your question.
Okay, does it?
Okay, hold on, for everybody, we're gonna lower the temperature in the room. So the objection will be non-responsive, because she did not answer your question, she answered a different question. Can you repeat your last question, Mr. Rogers?
Do you believe that a toy gun presents a threat of harm to those students?
He could. Yes, yes, it could.
Okay, explain. How in the world a toy gun could
A
present a...
BB gun, a water gun.
I said,
any kind.
my question was...
She answered the question, what's the next question?
Okay. So you consider a BB gun as a toy gun, is that correct?
It's a gun. You report for any type of weapon. I reported.
All right. Just going back a little bit, when the girls made this report to you, did you take them down to the office to speak to administration?
I did not.
All right. Do you think it may have been important to take them down to the office to?
I did the actions that I did in that day, and I cannot look in retrospect.
Somebody prepped her on that
Who
answer.
gave you the authority to check the backpack?
Do you think? Oops, wait a second. Do you think she should have taken the girls down to the principal? Like the judge taking down the temperature in the room. This witness is getting a little fiery. She's getting feisty, Ms. KOVAC.
Do you think it may have been important to take them down to the office to?
I did the actions that I did in that day, and I cannot look in retrospect.
Okay. Who gave you the authority to check the backpack?
According to the crisis plan, we are allowed to. We just cannot check their body without permission from the administrator.
Okay, so.
Oh, so they can check the backpack. They just can't touch the body of the student.
Did Dr. Parker give you the authority to check the book bag?
She acknowledged when she heard that I was going to do it. She could have gotten up and done it herself if she wanted to.
Okay, so let's talk about, you said you're a part of the crisis management team?
I'm not part of the crisis management plan. I said in the crisis plan.
Are you?
The district holds.
So you're not a part of the crisis management team or any kind of crisis team at the school?
No, I am the reading specialist, and if the principal and administration gives me another duty, then I do that.
Okay, but nobody.
You can't use it as a shield and a sword though, right? We talk about this a lot. You can't say the policy only gave the principal or the assistant principal or the school security officer the right to search the backpack, but then she's saying, oh no, I'm allowed to do it if I want to too. We're getting into shield and sword territory, which means that Abby could have also, right?
Told you, Dr. Okay, but nobody told you, Dr. Parker or otherwise, that you did not have the authority to remove JT from the classroom. Is that correct?
No.
When the police arrived and you were holding JT, were there any students in the classroom?
No.
Okay. At what point did the students leave the classroom?
When I was walking in, they were coming out.
Okay. So by the time that you took a hold of JT and sat down with him, there were no students in the classroom. Can I have a moment?
Okay.
I don't think he's badgering her. Oh, for over 50 Swifty. I see you. I see you, girl. Me too. I don't think he's badgering her. We have seen far worse badgering than this. This is mild The girls were 6. The girls were in the same class. They were 6 also, first graders. They said that the child was telling other students that he had a pew-pew in his backpack or
After
on him.
the firing of the firearm by JT, one of the steps that you took was to call the police. Is that correct?
Once I had told him, yes.
Okay. So that phone was readily available to contact the police?
It was her school office, it was her school phone.
Okay. Were there also walkie-talkies that could be used to communicate with administration?
There is, but I did not have my phone or my walkie because testing had just finished. And state testing, we did not have that. So I had none of those.
But you did have the classroom phone that you could have easily called down to the administrative office. Isn't that correct?
After the shooting, I did call. I was busy the whole time.
All right. So before then, you took no steps to call the police. Is that correct?
Correct.
And okay. So, but you did communicate with administration face to face. Is that correct?
Correct.
All right.
Several times.
Thank you. Elaine Murray says, as a former admin, I was responsible to respond to all reports of a possible dangerous situation immediately, whether it was a student or a teacher or any adult. She knew and did nothing. We don't know what her story is, right? Because she didn't testify.
After the incident, did you have communications with Dr. Parker?
Yes.
Okay. You understood that she was very upset about what the things that occurred on that day. Is that correct?
Well, first of all, I was in shock that day. I did speak to her. We were considered work friends. So I checked in on her. I asked her if she called her husband. I asked her if I could use her phone to call my husband.
Okay. And you indicated to her that the events that had occurred on that day were unfortunate.
Objection, hearsay.
Okay, so go ahead, finish your entire question.
You're right.
You indicated to her by some communications, by text or in person, that you believe that the events that occurred on that day were not foreseeable. Is that correct?
Okay, and hold on, that's what I'm looking for. Okay, your objection is what, you touched that a little bit more, Mr. Chamberlain.
So he's asking about an out-of-court statement offered for the truth of the matter. He's asking about an out-of-court statement that she said to Dr. Parker. So that is hearsay.
I'll submit it to the court.
So, all right, so, next question again.
Okay. And so just briefly going back to the backpack. So you searched it, didn't find anything that you believe presented a danger. Is that correct?
Not at the time, correct. Yes.
Okay. Did you observe at all JT on the playground? Did you observe what he was wearing? You know, anything that he may have had in his pockets?
No.
All right. I'm going to check with my co-counsel one more time.
Ron Gotti says, this was a known problem student. Again, catch 22. Go check because he's a problem or do nothing because it's just JT being JT. I mean, I believe that your right of privacy, the second you walk into a school building, you should lose your right of privacy. Everything should be searchable by administration. We need to keep our children safe.
I'm sorry, I just want to return to the backpack again. When you asked JT to search, to let you look into his backpack, and he said no, was that alarming to you?
I mean, his actions were alarming to me.
Okay. But,
Words that come out of his mouth, it's hot and cold every day.
So you're saying you didn't take that seriously?
I took it seriously because I reported 3 times to the administrator.
Okay, but not seriously enough to say, let's take JT to the office, or let's get his classmates out of this classroom because I think that.
Objection, asked and answered.
Talking about backpack now, Your
Honor. Go ahead.
All right. So not enough to take JT's classmates out of that room for any potential harm.
I did not know what his next actions would have been at that moment, and to keep the children safe if there was something, because a weapon had been reported and no administrator did actions.
Okay, so you could have taken some steps to keep them safe.
I did, as what I could at that time.
Okay, so that's all you could have done is reported to the administration. You couldn't have taken JT out of the classroom. You couldn't have taken the students out of the classroom.
In retrospect, maybe, but I did what I did.
That's all the questions I have.
Can you redirect?
No, Your Honor. Thank you, Ms. Clement.
And this what the status, in terms of being sequestered, excused?
I would request the same with all of our witnesses. I'm asking that she remain sequestered, but be able to leave. Certainly, she is subject to recall by either party. I agree.
Okay. Chatters in the chat who watched the rest of the day. Next witness up is Thomas Blythe. Thomas Blythe, he's a deputy. He responded to the school after the shooting. And he says a janitor opened the door for them. Blythe thought there was an active shooter. I want to focus, at least for today, on what happened before the shooting, what they knew, what they did, what they should have done, what they didn't do. Robin's like, yeah, did the boy shoot the teacher out of retaliation from the phone incident? I don't know. So the next witness up is the deputy. After that is BRIANA Foster. She's the principal of Richneck Elementary. And she's going to testify about calling the mom 2 days before when the cell phone was smashed. Then there is a grandmother of 2 children who was at the school at the time of the shooting. A teacher ran into the office and said there was a shooting. She helped the children to safety. And then there is Kelly Wells, a forensic services technician who responded to the classroom, saw the firearm on the floor by the table in front of the backpack. So what do you think? Should we watch the principal's testimony? BRIANA Foster, those of you who did watch already today with Law and Crime or someone else, let me know. Because we have, let's see how much time we have left here. 2 hours and 45 minutes with breaks and everything else. This is the deputy. He comes in after the fact. I don't know that that really has anything to do with our analysis for today. You can go back and watch this on Law and Crime or Court TV if you would like to do so. I'd like to hear from the principal. I would like to hear from the principal. This is BRIANA Foster. And I think it's important to hear from her maybe what the policies and procedures are. And where she was when this happened and, you know, what this kid's history was. And so let's, just because I don't have unlimited time tonight, and maybe you guys don't either. Principal's not on the stand long, says Pixie Poot. All right, here she is, BRIANA Foster. It's your show today because this was unplanned. Desert Quill said earlier, the defendant was warned a student had a deadly weapon, a student who has posed problems. She was obligated to act on her authority and respond. She ignored her duties and obligations. All of that may be true. I think the question here is, does that warrant criminal charges? She's already received a $10 million judgment against her in civil court. And was she really warned that there was a deadly weapon? Or did Ms. KOVAC say it might be a toy gun? Maybe it was a toy gun. I don't know. I kind of feel like she's got to testify in her own defense. She's got to testify because we don't know her side of it. She didn't testify in civil court. That's why this is a very interesting case to me. Patty said this testimony is enough for a not guilty for me. Talking about Ms. KOVAC. Robin said, does this all we covered this before about the school being let out of the civil suit. Kraft Haskell said it should have stopped with the mother's charges, and we covered this also. Scott says, simple solution. If any of the school employees had a duty to act and they didn't, they are negligent, right? Negligent is the standard in civil court. Civil court. Is there a criminal act here? And if there is that a very slippery slope? I don't know. I don't know the answer. I just need a latte. Says I've worked in a zero tolerance policy school, or even I've worked in a zero tolerance policy school where even having a toy gun would get you expelled no matter your age or grade. Not saying I agree or disagree, just stating the policy. Yeah. And listen, a million years ago when I was in elementary school, the policies were much different. You didn't have the expectation of privacy in a school. They could search your locker. They could search your backpack. They could do whatever they wanted. It was very, very, very different then. If you know, you know. If you're Gen X, you know. Liz said, I've worked with children for nearly 30 years. It's a big responsibility. There are more than 20 children in a class. Your eyes are everywhere as we are teaching, supporting them. Some schools have 30 in a class, right? Hello, Amon says, I'm trying to get caught up to you live. It's smooth as cruise. Hi there. Just given today. Thank you so much for your 5. Call me Murdoch. You've changed your name too. I have so many questions by coming on late. They may not all be answered because I didn't do a whole lot of a deep dive into this. Girl Ryan says, I do think if Dr. Parker, your thing keeps changing it to Dr. Pepper. We have a Dr. Pepper emoji. Disregarded the notice, she's culpable, but I don't think it quite reaches criminal charges. Am I making sense? I feel like no, you're totally making sense. She has been held liable in civil court for a $10 million verdict for Abby Zwerner's injuries that were sustained in the school for her failure to act. And this child is 6. I don't know. I have so many mixed feelings, but I see what you're saying. Thank you for your 10. Oh, hey, it's Allie says, if she isn't held criminally liable, what is a justified punishment for her inaction? A jury verdict of $10 million has already been reached in this case. And I think it was November of 2025. Is $10 million enough? I don't know. Abby Zwerner did have serious injuries. She is alive. Nobody died here too. You know, we got to keep things in perspective, right? Are they trying to teach a lesson to school administrators throughout the whole United States of America? Maybe. I just don't know what the answer is. I'm open to your suggestions. I just need a lot. He says, I work in grades 7 to 12. I'm not allowed to search bag or person. I can ask them to empty their bag or pockets, but I cannot search them. However, I do not take my eyes off of a bag or a person until searched. Let's see what the principal has to say. All right.
Amber?
Okay. Because this is direct again, I'm going to unboost the prosecutor and then I'm going to boost the witness if she's not speaking loudly enough. And hopefully tomorrow they will try and get it straight. This is the principal of the school.
Good afternoon. Would you please tell us your name? And Ms. Foster, back in January of 2023, how were you employed? Okay, I'm going to ask you to speak up a little bit. It can be kind of hard to hear. Did you say that you were the, did you repeat?
Yes, I was employed with Newport Public Schools as a principal.
Okay, and what school were you a principal at?
Richneck Elementary.
Okay. Ms. Foster, if you know, had your school at Richneck Elementary adopted a crisis and emergency management plan?
Yes.
And if I were to show you the plan, would you recognize it?
Yes.
Okay, Judge, may I approach?
You may.
Yes, yes.
The nuns. They're going to show the crisis management policy to the principal.
Just take a look at that document there, and I'll ask you some questions about it. You don't have to say anything about it this point.
Getting ahead of this, if they're going to have anything out of that document, it's going to be offered for proof of the matter of service, and I'm going to be objecting to that document. That's it.
All right. I'm still that's coming. And when it comes right, I'll be ready to hear the objection.
He's objecting to the crisis management plan as being hearsay. This is a great question. William says, if teachers in the broad sense are considered in loco parentis, which is what I think you meant to say, isn't this criminal/negligence issue analytically similar to prosecuting biological parents for the criminal acts of the child? Well, we've seen that, and we've been talking about that. We've seen, I think Crumbly was the first. The Crumbly parents were prosecuted for the criminal acts of their son, James Crumbly, who shot a number of students at a school and others. They were both criminally prosecuted and found guilty and are serving time for allowing their son to have access to a weapon. He was a lot older than 6, as I recall. And then there's another case, I think in Georgia, but is this a slippery slope? Is civil court the better place for this? If we start prosecuting the assistant principal and the principal, is it then going to trickle down to the teacher who's responsible for if a child shoots up other children? It's just, the whole thing is a slippery slope, if you ask me. Each case, I guess, stands on its own, but I don't know how I feel about this one yet. The mother has served her time. She's now out. I've been told she served over 3 years. This is a very different than it was in the 70s, right? In the 80s. Happy birthday. Happy birthday, not guilty. Happy birthday.
Ms. Foster, just let me know when you've had enough time to look at that document.
That's what it is. The Gray case in Georgia. Thank you, Shan. I have that question too, Rhonda. What did they do to the little boy? What happened to JT? I have no idea.
My question is going to be, is that a fair and accurate copy of the Richneck crisis management plan as you remember it?
I cannot answer that in full. I remember that it's a very accurate representation.
Understood. I'll take it back.
She was not there. She said, I mean, she's not there anymore. She's like, I don't know. I don't know if that's fair. So that's it. It's not coming in, I guess.
At the time that you were working on January 6th of 2023, were you aware of the crisis management plan?
Yes, I do recall that we have one.
Okay. And what was the purpose of having a crisis management plan at all?
We're just required to, every school is required to have one.
Okay. Was it your intention that you would follow the crisis management plan in a crisis?
Yes.
Okay. I want to take your attention then to January 6th of 2023. On that day, was there a crisis incident that occurred at the school?
Yes.
Okay. And what was that in brief?
Later that afternoon, I found out that there was a student who reported that a student had a weapon.
Okay.
Girl, you got to talk
At any point, was there a critical incident that required police to show up?
Would you mind clarifying what you mean, how?
Did something huge happen on January 6th of 2023? That's the whole reason we're here? Okay. And what was that?
That a student shot his teacher.
Yes. So I want to ask you, prior to...
That was a little bit rude to the principal. Was that a little bit rude? That's your witness, dude. That's your witness. Why do you have to be so harsh with her? Is it me? Am I overreacting? Listen to this again. I'm going to put it on just regular speed just for this exchange. Like you want her to say something that's in your favor and you're going to snap at her like that? What?
Okay. January. I'm going to take your attention then to January 6th of 2023. On that day, was there a crisis incident that occurred at the school?
Yes.
Okay. And what was that in brief?
Later that afternoon, I found out that there was a student who was reported that a student had a weapon.
Okay. At any point, was there a critical incident that required police to show up?
Would you mind clarifying what you mean, how?
All she asked for was, would you mind clarifying?
Did something huge happen on January 6th of 2023? That's the whole reason we're here? Okay. And what was that?
That a student shot his teacher.
Yes. So I want to ask you, prior to that moment, the moment of the shooting, Had anyone,
Your Honor, I'm sorry, I'm going to object to her response to the question unless she actually observed the incident. I don't think that she was present when that occurred, so she can testify to what she observed, but she has made a conclusion that I don't think she can really testify to.
Response.
Judge, it's the incident for which we are here. She's the principal of the school. She knows what happened at the school that day. I'm just trying to orient her in time so that I can ask a question.
So I'll overrule it as receiving that posture as to why are you here in court today, the incident that brings you in court today. Not that she observed it or anything further than that without further questions and testimony.
Thank you.
So what's your next question?
Prior to that event occurring at your school, did anyone tell you that JT or anyone that there was a weapon on campus?
Yeah.
No.
Any hint from anyone that there was a weapon on your campus prior to that?
Yeah.
Roughly how many students attended Richneck at that time? And I don't mean on that day, but just the total number of students that would have been in the school. And you can give us an estimate.
I truly do not recall, but if I had to give you a number, maybe 500.
Okay.
She said 900 students at the school. It's a lot for an elementary school, no? Wait a minute. Is that what she said, 900?
Recall, but if I had to give you a number, maybe 500.
Okay.
500?
I want to talk to you about a student named JT. Are you familiar with who I'm talking about?
Yes.
Okay. We're not using any student.
I think she said 500. I think you're right. All right, I'm going to speed it up a little bit. That was on regular speed. He says, I want to talk to you about a student named JT.
Names at all. So any students that you mentioned, please don't use their name. Had you personally,
500.
prior to the incident on January 6th, so earlier that year, had you personally had any issues with JT's behavior that you saw?
Yes.
That is not the job.
Okay, what's the judge? I didn't hear you.
No, that's your honor.
Right. Okay, response?
If she handled a discipline issue with JT that the defendant knows about, then it's relevant, as all of those are.
We allowed those in previously, so I'll allow this in to be consistent. So you may proceed. You can answer the question. Do you need him to repeat the question? Yes, please.
So the question was, in the time before, the days before the shooting, had you personally been aware or observed behavior of JT that was a discipline issue?
Yes.
And could you just describe that?
To my memory, earlier that week, there was a situation that took place between him and his first grade teacher involving her cell phone.
Okay, and did that situation come to you?
Yes.
And who appeared to you to inform you?
I think it was 2 people that came to me. I don't remember if it was his teacher.
Okay.
I'm sitting here trying to think back exactly how I knew about it, but I remember calling his mother that evening.
Okay. So as a result of that incident, you did contact his mother?
Yes.
Okay. Any other specific instances, discipline-wise, of JT that year that you remember? If you don't remember, that's fine to say that.
Not in detail, but there were other incidences that took place.
Okay. If you know, did the school attempt to do anything to try to moderate that behavior?
Yes.
And what was it that the school did to attempt to control behavior?
I don't remember the name of the process that was in place. However, they met, it was a scheduled number of, like, let's say weeks or about the month where they would meet with the teacher, assistant principal, parent, and KOVAC to go over his progress, academics, behaviors, and plan, essentially progress monitoring how he was doing it in school.
Okay. And I just have one last question for you. Is it true that you were working at the school hand in hand with Dr. Ebony Parker?
Yes.
Okay. And is Dr. Parker in the courtroom right now? Okay. Could you please just describe what she's wearing and identify her for the judge or point her out?
Yes. She has brown in my hair. I'm mistaken, she has some blue.
And does medical recognize she's identified the defendant?
Oh, no.
Thank you. I have no further questions for you. Please answer any questions at the time.
Thank you.
Can I take a minute?
Yes.
Okay, there's a big cross.
Good afternoon. How are you? Just a few questions. There was a crisis management plan in place. Is that correct?
To my knowledge, yes.
Okay. Okay. All right. I'm sorry. So there was a crisis management plan in place. Is that correct?
To my knowledge, yes.
Okay. And if there were any type of crisis at the school, had you instructed any of the teachers or staff not to come to you with that crisis?
No.
Okay. Was it the policy of your school for staff members to bring problems to Dr. Parker and if whatever she said goes? Or were you ultimately responsible for the safety of the students at your school?
To my knowledge, it's joint.
Joint?
In my previous positions, it's hard to say, but ultimately I am as a principal, yes.
Okay. So would you expect?
Bam, I think they just got her. She's ultimately responsible for everything that goes on in that school. I don't know. Something.
Your staff members, if they weren't satisfied with whatever was brought to the assistant principal, that they should bring whatever that crisis or problem to you?
Yes.
Okay. Did that occur on January 6th of 2023?
No.
Could any teacher who had a disruptive student in their class, could they have brought that student to the administrative office?
Yes.
Okay. Would you expect them to bring that student to the administrative office?
Yes.
If any teacher or staff member had the belief that there was a firearm possessed by a student, would you agree that that student should be separated from the rest of his classmates?
Yes.
Would you also agree that law enforcement should be immediately notified?
Yes.
These are all things that were not done by the teacher. He wasn't separated. Law enforcement wasn't notified. She says she wasn't notified either. Was she on campus that day?
Before the shooting, as far as you know, did any of those steps take place?
To my knowledge, no.
Have a moment.
Recross?
So
redirect.
on January 6th.
He's a loud talker. Gonna unboost him.
So on January 6th, during that day, what were you doing and where were you in the school?
Do you have a timeline of it?
As much as you remember, it's fair enough if you don't remember, you can say you don't remember, but just as much as you remember, where were you and what were you doing that day?
That day we had some interviews in the morning. I subbed for a teacher break so she could handle lunch or something, or lunchtime.
Now, when you were doing the interviews, where would you have been in the school? In your office, okay. And then the second thing you said you did was what again?
She had lunch break.
So that would have been in a classroom?
Yes.
Okay, then what?
Then I remember we had a family and military life meeting with a new partnership that we were forming.
Okay, where did that occur?
In our conference.
Okay.
And then after that, during that meeting, I remember emailing our lead custodian to ask about, I think I walked through an email our lead custodian. Maybe Dr. Parker asked me about space. They wanted to know about space, and I couldn't run off the top of my head really good with them. And then after that meeting was over, Dr. Parker and our lead custodian came to my office, in addition to students who were waiting to speak with me, came to my office.
Okay. And while you're in your office, what's the first signal you get that something is wrong?
I think the words I heard were, he has a gun, or she's been shot.
Okay.
And
That's her first indication was he has a gun or she's been shot. Let's hear that again.
two students who were waiting to speak with me came to my office.
Okay. And while you're in your office, what's the first signal you get that something is wrong?
I think the words I heard were, he has a gun, or she's been shot.
Okay.
And then
What did you do?
from there, I slammed my door and I took the two students who were in my office and everyone else, and I shoved them into the bathroom and tried to barricade them in. I called my direct supervisor and 911, and we were telling everyone in the bathroom that I'm going out. And I remember someone saying, "You can't." I have to. And then when I went out, Dr. Zwerner, Miss Zwerner, was on the ground and there were staff. And I remember saying, like, please put the school on lockdown. And Miss O looked up. I looked up and Miss O said she had already put the school on lockdown.
All right. Thank you. I don't have anything further for you.
You don't have to follow.
Thank you. I the status of this witness?
I would ask that she be constructively sequestered and subject to recall.
She took cover. Call 911.
What that means is, they're done with their testimony for now. They may recall you to come back to the witness stand, but you don't have to physically stay in the building. So you may leave the building and just make sure that the contact information is good. So if they need to recall you as a witness, they can. You cannot stay in the courtroom and you cannot discuss the case until it's over.
Does that mean for the remainder of the trial?
Well, yes, for the remainder of this criminal trial, until this trial is concluded, you cannot discuss your testimony. You are a sequestered witness, but we are not going to require you to remain in the witness room. So you can go about your day and be available for you to call you back. And they'll let you know when the trial is ended. Okay, so with that, when your sequestration ends. All right, thank you very much.
Okay. And that is the principal's testimony. What do you think so far? There was a long lunch break. They came back from lunch at like 2:45. And then, who do we have here? She was an eyewitness. She was a grandma of 2 children. She was at the school at the time of the shooting. Again, doesn't go to prior notice, which is really what I'm looking for here. And then there was a forensic services technician. Let me just refresh this and see if there were any further updates after I refreshed this article last time. Oh, please. Any other testimony that if you have watched this already today on another channel that you think is important to our so far analysis? Where is this? Hold on. Thought I had the live updates, but maybe it's not on this article. So please. And this is they're calling this day 2 because day 1 was jury selection. I'm calling this day 1 because this is day 1 of testimony, including openings. And oh, here it is. Here's something else that happened. There was after this incident in 2023, there was a 2024 grand jury report issue that found multiple safety concerns and administrative failures leading up to the shooting, in which first grade teacher Abby Zwerner was shot by a 6-year-old student who brought a gun to school. In response to the incident, the school division introduced several new security measures aimed at improving safety across all campuses. Those upgrades include weapon detection systems, clear backpack requirements, expanded security staffing, and stricter visitor access procedures. According to Dr. James Graves, president of the Newport News Education Association, the changes have made a noticeable difference in school security. I think that made a big difference. Graves said it's out there now that every Newport News public school has a weapon detection system. They have a security officer at the door taking IDs, and the doors are locked so you can't just come in. My kid's high school has been like that for a very long time. Graves, who also works as a teacher, says the enhanced measures have improved safety from outside threats, but believes more attention is needed to address violence and disruptive behavior occurring inside schools. Again, this child was 6 years old. So some changes were made. Is prosecuting this assistant principal criminally going to make anything change? Is it just going to have the effect of scaring administrators and making nobody want to go into school administration or teaching? In the future, we need teachers. The children is our future. The children are our future. Bachwood, I don't know anything about this, said JT stole his mother's car at least twice and crashed it once. He took the keys out of her purse at 6 years old or 5 years old. That's an awesome improvement, right? Laura says, I don't know what to think. I'm still kind of in shock that a 6-year-old has so many problems. Mini Secret Recipe, thanks for your 20. Says, thanks for all the effort adjusting the sound modulation, the sound modulator. It made such a huge difference. Oh, good. I'm glad. Thank you. Another thought-provoking trial so far. I love you with all of my heart. I love you with all of my heart, too. And Dominique says, I would have thought it was just a civil matter if it were not for the fact that Dr. P never even left her computer during the entire incident. You must have learned that at the civil trial, but we're not hearing that so far at the criminal trial, right? And the jury's not supposed to know about that. Will she testify? I don't know. Has anybody said she never left her computer? Not yet in this trial. So you know more than the average juror or even the average person watching this trial today who didn't watch the civil trial. Timothy Shortstack said the kid stole his mom's car keys and crashed her car prior to this incident. So storing a pew-pew on a dresser doesn't seem adequate for this kid. I mean, all great points. But again, we're not going to hear about that. The jury's not going to hear about that in this trial. At Ford Dredd said his mom lied on the application to obtain a firearm and she was federally charged for fraud. I think she's just been released, is what I'm hearing. I don't know. But again, this is all stuff that the jury's not going to hear about. You had another great comment before. I'm sorry I didn't address it. But you said the teachers should have called the cops, plain and simple. I don't blame the teachers or the vice principal. I think it's a very bad look blaming these educators for a freak incident with a 6-year-old. I think that's very well put. I think that's very well put. And Goblin Misfit says this feels like a twisted version of the Uvalde officer. Right. At Ford Dredd, another prior comment. Your comments today have been very on point. Said, how do they allegedly know that he has a gun, but they let him have lunch and recess? And so I don't know, but it seems like we are learning from what I just read you, and this is covered by 13 News Now, that because of a grand jury convening to look at the policies of the school, a lot of changes were made. Across the Newport News Public School District after the shooting. He said that teachers, he says, I feel safer from the outside of someone coming in. I think Newport News as public schools in partnership with us need to work on the behavior aspect from the inside of the schools. He said the teachers and staff continue to face verbal abuse and physical assaults from students, despite the added security infrastructure designed to keep weapons out of schools. Try that with the nuns back in the 70s and 80s, okay? Try that with the nuns. I do believe that if a child wants to use profanity and assault a teacher or staff, there should be consequences, Graves said. Yeah, 100%. Are there not? I guess there's not. Currently, Graves says that students involved in violent incidents may face suspension, but Graves believes stronger legal accountability is necessary. He argues that criminal charges should automatically be considered in cases involving assaults on teachers or school staff. Right now, you've got a teacher or staff running around to the magistrate trying to get a warrant for a student. Graves says we need to make sure that if a teacher or staff member gets assaulted, then the Commonwealth's attorney gets on it automatically, just like a DV case. And they're still working on trying to make some new policy with regard. I don't know. I don't know what happened to the student. I don't think the jury's going to hear anything about that. It is such a tragedy. I mean, Kylie says, coming from EMS, you treat a report as a threat until proven otherwise. This sounds like complacency and failure of the chain of command. Lady Tammy says, Melanie, would you feel the same if the teacher had died? Would it change my analysis? I don't know. I mean, if you're going to prosecute administrators for failing to act, and we haven't seen all the facts yet, and you want to overcharge, maybe that would be a case to overcharge in. And that's a great question. I'd have to think about it. Oh, please. Priscilla said, we did hear that. She stayed at her desk and then she actually holed up in her office. We heard that during this trial today. Today? I mean, well, the Miss, what's her name already? I forgot her name. Miss KOVAC said that she didn't look up or something. She didn't leave her desk at the point when she was in there complaining to her, but I don't know if she left her desk for the Miss KOVAC. I mean, listen, I think it's a hot button issue. I think everyone's going to have different opinions on this. Right? Oh, hey, it's Allie says, I love this live, forcing us to critically think. All of us. Yeah. I mean, I want to hear from the teachers. I want to hear from school administrators in the chat. I want to hear from parents in the chat. I mean, at what point does it become an incredibly unlikely intervention of an act? I mean, an incredibly unlikely breaking the chain of causation act of a 6-year-old bringing in a firearm to school. I mean, I guess you got to be prepared for everything. It was said in opening statements. That's not evidence. It's not evidence. Amanda, great point, but it's not evidence. Is there going to be evidence that says she never left her desk? I don't know. Is she going to testify and tell us that she did do some things? I don't know. Again, if it's in openings, that's not evidence. They said a lot of things in openings of the trial of Edric Faust that never came to be, right? And other trials that we've watched where prosecutors open on stuff and then they never prove it. There was a civil trial for this, a civil trial. Dr. Dr. Parker was sued by Abby Zwerner, the teacher who was shot, was sued, as were, I think, the school district and maybe, I'm not sure, other municipal defendants. They were let out of the case. Jury came back with a $10 million verdict against Dr. Parker on behalf of Abby Zwerner for her injuries from being shot. Cupcakes or Justice says, when we were in school, we were held accountable and punished today. Nothing happens. It's sad. See? Wendy says, I guess you have not brainwashed us after all. After all, everyone has different opinions. This is a really interesting case because so far, I don't know that I've even really heard. Well, I'm going to have to go back and rewatch this before I say that. Because now we're kind of going outside the scope and we're looking at other things that are happening in this case without just, like I said, we were going to do, just listening to what happens inside the courtroom and not even listening to the arguments outside. Outside the presence of the jury. So the school district did make a lot of changes after this, but I mean, have they gone too far? Is it just like, we've already filed the charges, we're not going to withdraw them now because these school administrators need to learn a lesson? Even though our policies were so poor that we allowed a 6-year-old to bring a firearm into an elementary school? Patty says, it sounds like nobody took JT seriously until after the fact. Everyone went about their day because JT was a troubled kid. They took the cell phone issue more seriously, right? I hope that he's getting the help somewhere that he needs. And his mom, I don't know if she was a bad parent. I don't know if she did the best she could. She did her time. And I wonder what caused him to do. Was he being relentlessly bullied and nobody did anything about it? Did the mom come into school a million times and complain that her son was being relentlessly bullied and they just turned a blind eye to it? Like, that would make more sense to me. I just don't know why he shot his teacher. 6 years old. How do you even know how to handle a firearm at that age? Real says, no, I think he was mad because she took his phone the day before. Wait a second. I thought he took her phone and smashed it. I thought he smashed her phone. I mean, is that what happened? He smashed her phone and he got in trouble for that. And then he didn't come to school the next day, but this was like the day after the next day. Allie says, seriously, many adults don't know how to handle one. Scott McGinnis says, I mean, I can't stand the defendant. I think she was a miserable failure, but I don't see the Commonwealth convicting her on the trumped up charges. Yeah, 2 days prior to the incident, the kid smashed the teacher's phone. That's what happened. Marie N said, in my opinion, the defendant will not testify 100%. Also, I do believe she couldn't be bothered with dealing with JT. In my opinion, sorry, but I'm leaning towards guilty. Good as Citizen Weymouth says, don't mess with my kids. If the teacher and police don't listen, yes, I went to Boston 25 and it was all over the news. Oh, thank you. Thanks, Jamie or Jaime Sepulveda. The 6-year-old boy was not criminally charged because authorities determined he was too young to understand the legal system. Where do you draw the line? What age? What age? Remember Carly Gregg, 14 years old, tried as an adult. She's spending life with ever having the possibility of parole in a Mississippi prison. She was 14. JT was placed in a medical facility for treatment following the incident, says the Venus Blue Cupcake. Bob Dylan says, as a teacher, I believe the assistant principal should have investigated when the reports were made that the student had a gun. Kelly says, I'm a teacher. I would have searched. Maximum Eric Bacon says, I just don't see the legal obligation to act when even cops don't have that obligation. Oh, Dave Matthews' neighbor says, it's only 30 minutes from my house. I'm going to try to go to the courthouse tomorrow. Rock on, Dave Matthews' neighbor. New Hampshire woman says, that child should not have been allowed in that school. He should have been either homeschooled or in a special school. But what do we know about him? What do we know about him? How can you make that determination? Did you do outside research? I mean, sometimes things like this happen without ever having any preview of the events or any prior warning or any indication that a child could do something like this. Aurora says, I don't know. Former teacher and bus driver, mom of 12. Holy crap, girl. You are getting things done in your world. Last two are extremely troubled. Former foster, now adopted. I've been pleading, begging for help for them. None. I'm so sorry. If anybody has any advice for Aurora Knight 3779, please tag her in your comments. Petty Patty says he had behavior issues in kindergarten and was on a modified schedule in first grade. I mean, a lot of children do, right? Law Junkie says most 6-year-olds don't have the ability to plan a crime like this and carry it over days. Weird. This seems odd. PK says many troubled kids that act up and are violent are really smart. I don't know. I just don't know. Astro says, I had a kid who would leave the class and run around the school, going into other classes and breaking stuff. Admin did nothing. I'm not surprised this is what it took for admin to act. Tara says, I'm telling you from firsthand experience with a relative, a 6-year-old child who has not been bullied, who has loving but overwhelmed parents, can absolutely behave this way. Goblin Misfit said, I don't think Parker ignored everything. The teacher testified that the teacher, would search the bag during recess. Right, the reading teacher did search the bag and there was nothing in it. And then he got her to say that she thought that if the kids were telling her that it was probably a toy gun, so people weren't taking it seriously. I just don't know. I just don't know what the right answer is. I don't know what the right verdict is. We're only on day one of this trial, and I am very conflicted. I don't know about you. I mean, stealing is. All right. Are you guys interested in continuing to follow this case tomorrow? I will, of course, once I find out what the summary of the rest of the testimony was for the day, I will summarize it for you tomorrow. Are you interested in covering this case tomorrow? It's supposed to only be a couple of days. Should end by Thursday or Friday. What say you? Are you interested? Should we keep going? Should we do it tomorrow in real time? Yes, please. Yes, please. Yes, please. You say. All right. All right. You guys are in. You're invested now. You're invested. Okay. We've got a new trial, Cupcakes. We've got a new trial. Wait a second, Paula, you're making a wedding cake for yourself or for other people? Are you a wedding cake maker? I love that for you. Lady Di says, I want to hear his last year's teacher. Did that testimony happen today? Jen's just watching said, I was convinced in the civil trial she was 100% negligent, right? Totally different standard. I'm so surprised at the difference here. It doesn't look like she should be held accountable criminally. I'm glad you watched both and that you have a different opinion. Sherilyn says, I feel like with the text messages and all the communications, if you're going to blame Parker, there's a whole line of people behind her, a bridge too far. Right. Maybe. That's a great point, Sherilyn. There's so many more issues here. You're right, Scott. All right. Here's what we're going to do, though. Tomorrow, we're going to start at 10 a.m. So we're going to be on a little bit of a delay. Oh, wait. Also, the live feed is on a half an hour delay, right? So does that mean they don't start their live feed until 9:30? The court has them coming in. What time should we start? What time should we start? Let's start at, I know, I have this in my calendar. Oral arguments, 10:30 a.m. for Carly Gregg, Wednesday, May 27. That's a week from tomorrow. This case will be over by then. 11. All right, 11. Let's do 11. So don't watch it. Don't cheat and watch it ahead of time. You will start with me at 11. Tell your friends. Tell your friends we got a new one. All right? We got a new one for tomorrow. Eastern. 10 Eastern. This is in Eastern. And we'll start at 10:30 so we can have a little chat before that, catch some people up. All right? Just check my channel and make sure your notifications is set so you're going to get them. All right? 11. You want 11? You want 11 so we could. All right. Because she ends at 4. I feel like there's a lot of argument. There's a lot of stuff that we can fast forward. It seems like they have a long lunch break and stuff. So tomorrow, 11 a.m. Eastern time. No cheating. I mean, you could cheat if you want to, but always come back to me at 11, all right? Stay cool, stay kind, stay classy. I love you all so much for spending so much of your time with me. Hold on a second. Tammy said this earlier, and I don't know what she's talking about. Sorry, Melanie, not trying to be a pest, but the case of DV against a sitting chief judge with a legacy of 4 generations of judges and family as clerks of court on Cape Cod is a big effing deal. You're not being a pest at all, but I don't know what you're talking about. I'll take a look at it when I can. Thank you guys for jumping in here with me unscheduled. Thanks to the moderators. I love you so much. Couldn't do this without you. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. And I will see you tomorrow at what time did I say? 11 a.m. Oh, look, something shiny. Oh, and let's go Avs. I got my hat on. We hockey fans are very, very superstitious. And so I may wear this hat every single day until the Avs move on to the Stanley Cup. Okay? And every day thereafter, if they do win the Stanley Cup. So there's that. And congratulations to all the Montreal fans, because Montreal won last night. And that was a pretty awesome game, too. And hockey playoff season is my favorite season of the year, as I have told you before. And so thank you for being involved in this trial with me and being interested in this trial. And we'll get there. We'll do it tomorrow starting at 11 a.m. All right. I love you guys so much. Oh, isn't it the nights? Yeah, you guys, I know. See, here's the thing. Oh my God. Well, let's just talk about this for a second before we say goodbye. John Tortorella. Did you see what happened with Torts? So when the Golden Knights won, John Tortorella, who used to coach the New York Rangers, who's really my favorite team years ago, John Tortorella, in violation of the NHL rules, refused to do the handshake, refused to speak to media after the win, and got fined $100,000. $100,000, and they lost the second round draft pick, right? I think that was the final punishment. I don't know if they I don't know if Torts is appealing, because they were going to have to appear in New York City this week to appeal in person. And knowing Torts, he would have just been like, yeah, F you. I'm not paying my $100,000. I'd pay. He'd be like, I'm going to pay $100,000 rather than go into the NHL office. Screw you. I'll take the punishment. Right. He had 2 players come out for the presser and he made it quick. I know. And that's why I was rooting for Vegas until they're now playing the Avs. And so now I got to pick. Torts is always and always has been a hothead. Oh, he lost the appeal. He did appeal it. So he had to pay his $100,000. When did that happen today? Oops. Now my phone thinks I'm talking to, I can't keep up on all the news. See, Scott, now that is something you should have texted me about. Yeah. $100,000 for him to pay personally. I don't think the team is paying it. I think he's playing it, because those are the rules. You know, hockey, they're pretty strict with their rules. That's crazy. $100,000. Like, subscribe. It's free. It's free. He lost the appeal. You guys knew it. I didn't even look today. Thank you, MF, who says parents have made it impossible to hold students accountable for behaviors. Admin throws their hands up and says, oh, well, do what you can with them. It's terrible. They did lose a draft pick too, and $100,000 fine. Second round draft pick. Yep. Oh, Scott says that I should represent Torts against the NHL. I don't know if he wants to call me. If he wants to call me, he can. Wouldn't that be a hoot? Wouldn't that be a hoot? All right, you guys. Hey, girl. Hey. Hey, girl. Hey. All right. We watched most of the testimony today, not all of it. Tomorrow we're going to start at 11, and we're going to be able to fast forward or FF it through much of the testimony. So come back tomorrow, 11 a.m. Ooh. Stop. I don't know. I got volume coming from somewhere. I don't even know where it is. Okay, stop. All of it. Love you guys. I'll see you tomorrow at 11 a.m. Eastern. I'll see you later. Peace. Bye.